It has found that the finding has been given there is no encroachment. The only issue which was directed was to state whether there was a deemed license or not. Without considering it, now they have given one more notice.
Good. Take the memos. Emergent matter tomorrow. Otherwise, no. Yes. But if there is a threat of demolition, please write on the memos. If there is a demolition threat, please write on the memos. The matter will come up tomorrow. Infill. Yes.
Page adjustment. Page 4, number 30 to 37.
34. (2013) the dispute regarding change of khata. क्या होगा? You offer the request of the counsel of the petitioner is date for the motion.
31.
31. Okay, withdrawing. This is regarding the implementation of guidelines.
Yes.
Counsel for the petitioner filed memo dated 27/10/2022 seeking withdrawal of the petition to avail alternate remedy if any provided under law. Memo taken on record. Petition dismissed as withdrawn. Yes.
Page 5, number 38 and 39. Page 6, 42, 46. Page 7, number 47 to 57.
I agree with the response of the 5 to 8.
You will have to make a submission if you have any personal inconvenience. Those submission will not accept. Make a mention and the matter is called. This court is not waiting for anybody. Yes. You offer? Illa Barley. You people don't inform. They'll come and make allegations against you later. Have you informed them? Madidira. Your number has Kamesru? Somshekar. See Somshekar appearing for the response number 1 to 3. Na? Adjournment. He informs that he has informed. He submitted. He has already informed to the petitioner counsel. Yaar move ಮಾಡಿರೋದು?
Blood. I appear for the petitioner in serial number 56, my lord.
Yes. Has he informed?
There is some urgency in view. The only issue, my lord, pertains to issue of
Has he
Khata.
informed you regarding the adjournment, madam?
But could it be taken up on Monday, my lord, if it is convenient to your lordships?
Yes, Monday. Just once.
Page 8, number 58 and 59.
Yes.
And my construction is stopped with the operation. Corporation given undertaking that they will remove the road and try to for minimum, directing the corporation to implement the orders of the commissioner. Now the regiment says that the private parties have filed objections. Those objections are prepared before undertaking taking into consideration. Some offenses with that act.
Yes.
Next one, fresh matter, same number 1.
What's your locus stand in this matter? Who are you? Where is the property located? Point out which survey number and which part of the property your property is located. Which southern side? Where have you mentioned? How is the plan objecting you, obstructing you? Correct, sir. Neighboring owner means how is it obstructing you? Point out that. Where is the pleading specifically? You have made a general governments. We don't entertain this kind of petitions. Authorities will decide, sir, if there is a violation of the sanction plan. You point out how is this affecting your right? Point out that from your petition. Show which is the road they're blocking. Point out from the petition. Your petition is very, very generic in sense. There is no specific government in the petition. We have seen all that. Point from the petition. Which portion of your property is abutting the layout? There's 23 acres of layout. Which show from your petition. Show the schedule. That's why we are asking. We made the state observation to you. You are making this now. What amendment application? Withdraw this and file separate. This is, you will have to make. You will not allow you to take this kind of forum shopping. Authorities will take care if there is a violation of it. They will take care of the situation. Show your locus standi, sir. We will allow your petition right now. Show your locus standi.
This is the property of the respondent number 8. Now they are constructing the.
Come to Annex D. Show the plan. Show from which side of your property you are located there. Come to Annex D. Point out where is your property located. Which road is blocked.
Survey number 8, my property.
Show, sir.
Right number 8. Survey
Sure.
number 8.
Where is it?
There is a road to our survey number 8. Your Honor.
Where is it?
This is the property. This is the south. Two roads is there. That blocked my.
Don't you have any other road?
No, sir.
Don't you have alternate road?
No. Only except.
Where have you pleaded in the petition? That you don't have a road and your road is blocked. Where have you pleaded in the petition? Read the paragraph. Read.
After that, after all, gate, entire area of.
That is a condition. You have extracted the condition number 10. Paragraph 5 of the petition, you have extracted condition number 10 of the sanction plan.
As per their plan.
You cannot improve your case at the time of admission, Mr. Counsel. You cannot improve your case at the time of admission. Para number 5 is the repetition of condition number 10 of the sanction plan, nothing else.
I have stated I am the adjacent owner of the entire.
We asked you. Choice is yours. Adjacent is sufficient. Yes, madam.
No, the entire government of the writ petition, blood, and moreover, blood, it is something for this prayer, blood. No local stand and the asset, blood. Even in para 6, blood, nothing is forthcoming.
Yes, but
So,
we are not here to look into the disputed question. Who is disputing your owner, sir? What are we asking? What are you answering? Present petition is filed. Seeking following reliefs. Except stating that the sanction plan annexure D is that the property of the petitioner is situated adjacent to the layout sanctioned at annexure D. Nothing has been stated in the petition.
Total area is 23 acres, 31.
Nothing is stated in the petition. Then council, then HCGT, additional advocate. And AGA submits that the petitioner has no locus standi to maintain the petition, as he has not specifically made any argument as to how annexure D is affecting his rights. It is further submitted that should there be any violation of the sanction plan, authorities would look into the matter and take necessary action. Full stop. Despite a pointed question to the petitioner, he is unable to point out as to the breach of his statutory / constitutional remedy, constitutional rights. He also not able to make out from the records made available in the petition as to whether his access to the property has been blocked. Be that as it is, in view of the aforesaid fact situation, and in view of petitioner not being able to establish his local standing and breach of any of his rights, nothing survived for consideration matter. Petition dismissed. That you are entitled, sir.
Number 2, remember.
Sir, please point out which provision of the Act says that you're entitled to B Khata. Please point out that. No, you point out law which says that you're entitled to B Khata. Please point out. No, your relief is that. Please point out from 114 that there's a provision to allot A Khata, B Khata, C Khata. Please point out. Then how can you ask that prayer? What is B Khata? Your case is of a dispute, sir. Your case is of a dispute. Read the endorsement. Read the endorsement, sir. Read endorsement, sir. Read endorsement. Page 46. Please read. Tax is different, sir. There's a dispute. There is a dispute in this matter. You notice? Yes. Adu, please explain how. You can't give the legal acceptance to that. Yes. What is wrong with this? There is an exemption provided section 7. Alienation for the purpose of central government. Correct. But the alienation is for the benefit of the state, sir.
And when the land is taken back, the informed consent should be taken about without the person is illiterate. That is what I'm trying to extend.
Section 7, read section 7 of the Act, sir, please. Read section 7 of the Act and point out what is wrong with page number 40. Why again keep this alive unnecessarily? They have considered it. Read section 7 of the Act. It's your own case that the portion of the property is taken for the formation of a layout for the deserving candidate by the state.
But this portion has not been taken. It has not been used.
Yes, madam. 7 is an exemption of the application of the Act.
Section 7.
Nodi Heli. He has raised the contention that he has not been heard. Astay or Virod.
Well, and we'll hear it, Lord, when then we pass an order. If at all it will not be done.
It's also like here, my lord, the land has been taken. If they don't know the land is taken. Tenancy is surrendered. The Tahsildar or Mahalagar will have to inform the farmer, the cultivator, that this is the land we are taking back from tomorrow, not having the land for cultivation. Something should be there in the law, when the land is going to the weaker section, because the can section are the sovereign state, the state government take it by law.
Why not? Why not?
Under section 28, we have the land right to the Lord. Some consent will be taken of the land, this thing. It's a, I'm losing my word, right of this is my word, Baker's New Society. I've been taken away by section 7.
No, you read your petition. 1 acre, 20 guntas of land out of 2 acres has been transferred by you. Tamminda transfer agide adu.
They have taken the registered document.
Sure, you can't come up and say I'm illiterate, I did not understand the purport of the document. It's a case of a transfer under section 7, sir. Nodi madam, nodi heli. The DGA to take notice. Petition serve copy of the petition along with the annexure. Is this matter? Could it date? No. This is for the public cause, sir.
My client was just conveying status to my candidate.
This is for the public cause.
10th November.
10th ಗೆ date ಕೊಡ್ಲಿ ಹೇಳಿ, we'll see. Hear that and pass the orders. Copy ಕೊಡಿ ಅವರಿಗೆ.
Lord, in serial number 4, the description of the second respondent is not correct. He has mentioned it as chief officer, town municipality.
ತಾವು ಯಾರಿಗೆ?
Nanu, I am standing counsel for Nelmangla City Municipal Council.
There is an alternate remedy available for you under the act. ಹೌದು, ಅದಕ್ಕೆ ಅವಾಗ ಅದಕ್ಕೂ ಹಂಗೆ ಹೇಳಿದ್ದು. Because this subject matter of that special legislation. ತಾವೇನೋ ಕೊಡಿ. ತಾವು ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ?
I'll take notice, but it should be amended as city municipality, not town. Second respondent,
Nelmangala
is a city municipality by commissioner.
Shri Mahesh Shivappa, the council.
Yes, Mahesh anta helbidi dayavitu.
Yes, Mahesh.
Yes.
Undertakes to file wakalat for respondent number 2. Idu yarige first respondent ge yaru? Yaru? First respondent ge yaru? Managing Director, Public Corporation, Land Corporation. Yaru? Yarappa idu? Karnataka Public Land Corporation. ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಪ್ಪ ಇದು? ಈ ಪಾರ್ಟಿಗಳು ಯಾರ್ಯಾರು ಮಾಡಿದಿರಲ್ಲ, ಇದ್ಯಾರಿದು? ಕರ್ನಾಟಕ ಮ್ಯಾನೇಜಿಂಗ್ ಪಬ್ಲಿಕ್ ಲ್ಯಾಂಡ್ ಕಾರ್ಪೊರೇಷನ್ ಅಂದ್ರೆ ಏನಿದು?
ಕರ್ನಾಟಕ ಸಾರ್ವಜನಿಕ ಜಮೀನುಗಳ ನಿಗಮ ನಿಗಂತ.
ನೋಡಿ ಅದ್ ನೋಡಿ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ ಪಾರ್ಟಿಸ್ಗೆ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪೆಟಿಷನ್ seeks weeks accommodation to ascertain the proper designation, description and the address of the respondents. Notice ಆಮೇಲೆ ಕೊಡೋಣ.
Both the respondents.
both ಇಬ್ರಿಗೆ ನೋಡಿ ಹಾಕಿ ಆಮೇಲೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಬೇಡ. Yes.
Much of life.
Number 5, Retrieve Prakash.
What school you want incorporate now? That was for the purpose of kindergarten makligoskara. What school you are intending now? No, what is the school you want now? You seem to be wanting some other school. No, education purpose is different, and the purpose for which it was reserved is different. No, not residential school. What not? Illa, not residential school antilla. Nodi. Play home, sir. Adu. Yes. SCGP is directed to take notice of respondent number 1. Issue either your Mudag yaridare notice hogbeka avrige. Issue notice to respond number 2 to 5. Yes. Serve the purpose.
Number 6, Sudhakar Devi.
Similar matters pending. Adama. That's ground rent. Entry mod. Connected repetition numbers. Kodima.
We have stated minutes that we deposit 4 lakh.
50%.
ಅದರಲ್ಲಿ
50%. 50%.
ಡೈರೆಕ್ಟೆಡ್
50%. ಅದೆಲ್ಲ consistent 50% ಇದೆಲ್ಲ. 50% and then ಅದಕ್ಕೆ 25 rupees per square meter. The rest will be stay subject to you per the same bar. Yes. Sanction plus subject to payment, yes.
7, 15,
Same thing. How did father get the money? Have you produced the account, bank account? Bank account the father ಹೇಳಿದ ಬಂತು ಹಣ. No, the pattern of this petition giving some kind of doubt in the entire process. ಹೌದು ಅದಕ್ಕೆ ಹೇಳ್ತಿರೋದು ಅದು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತಾ ಇದ್ವಿ. The pattern seems to be something. It's not reaching the beneficiary. Page number 4 of what? How did the father get the money, sir? ಎಲ್ಲಿದೆ ಕೊಡಿ. Why this pattern in every case? The deserving candidate amount is paid by somebody else's account. Have you looked into that matter? No. The question is not about the appeal, ma. About the payment of the earnest deposit. Same pattern every brother-in-law account in the barta untu, appon account in the barta untu, mother-in-law account in the barta untu. Put the bank account, Saturday. Counsel for the petitioner seeks accommodation to furnish the bank statement of the father of the petitioner for having deposited the amount of EMD amount. List on Saturday.
Number 8.
No, that's difficult alva. Avaru fire fighting itkondidaare. Avaru elli kodtare? Idea available idea. Now the alternate site is also auction agbekkalla. Issue notice to the respondents. Date could. You have to establish a right to. Alternative is a concession given to you. Concession given to you. That will be considered because of hardship.
Other matter, number 9, consume beer.
2:30. Who is the starting person?
Sunil Kantappa. Permission.
Permission ಆಗಿಲ್ಲ. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ.
Okay. More Devi.
Somebody has tried it. Ingredient. And finding. ಯಾರು ಅಪ್ಲಿಕೇಶನ್ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಯಾರಂತ ಗೊತ್ತಿಲ್ವಾ ಅದು? You are for the petitioner.
Yes.
2 weeks. Imprimatur granted earlier, extended till next appear.
December 12. That is
None appears 1 week.
13. In August 5. Petition.
1 week.
14. PHP Manjuna.
1 week.
15.
Last week was I was 5 months.
1 and 2.
5 months. Finish.
Respond 1 and 2. Ga?
Oh, finish.
What does this matter?
By invoking government to the women for years, the Karnataka Municipal Corporation Act.
Review.
Yes, please.
Fabrication document.
Yes. That is what they are considering.
Late, my lord, it's a late, originally it is a late. To slip the mind, a lot of the authority is concerned at a relevant point of time. Now the DB.
The request of the council for the request of the council for ಇದು ಯಾರು ವಕಾಲತ್ ಹಾಕಿರೋದು ಇವಾಗ?
I mean, I had 5 these words for
ದೇವೇಂದ್ರಪ್ಪ ಅಂತಿತ್ತಲ್ಲ.
innocent, come on, innocent.
Okay. Yes.
I find that these words on 9.
Yes. All right. The request the council to respond 1 and 2. This is matter. Let put it.
2 weeks later, I know. Even
14 November.
14 number enabling them to file statement of objections. Yes.
Other council's name is kind of.
Yes. Delete the name of Sri Devendrappa and reflect the name also. Yes. Imprimatur granted earlier, extended to next set appear.
I will go at that.
ಕೊಡ್ತಾರೆ.
That.
ಕೊಡ್ಲೇಬೇಕು.
December 16.
Number 2 ga Sri Soumyaji is directed to take notice to respond. Number 2 na. Yes. What about others? Yes. Yes. List this matter for yes.
14 November. 17.
1 week. 1 week.
18.
I prepare the petitioner by week's time.
1 week.
19.
1 week. Third time, ma.
20.
2 weeks.
21.
Office objection ಏನಪ್ಪ? What is up? You are not made complainant as a party. Huh? What is complaint? What is this matter? Huh? Is he your neighbor?
He is not a neighbor. Just far relation.
Why district court? So
Number 22 is Dia Manand.
Submission is not. And the P and M would not, the respondent of passing the order, they are sent by RPA, to the petition. So seal of the matter, the office, the respondent, so they have put the seal in the front page of the each document. So that is the, each page, round seal in the each page of the document is not possible in the office of it. But they have sent that document by RPA. So they put signature.
Where is RPD cover? Where is RPD cover?
RPD cover, I am not sure.
Mate? If it is sent by RPD, you should have produced RPD cover.
After resolving the matter for order, they have sent by post.
Now, what is this matter? What is this matter?
Matter with regard to that. The property is not. Father, the petitioner number 3 to 4 are purchased two sides. While the two registered sending to that annexure A and B. That. So after they are to after the father for these petitioners were working as a teacher lecturer, so that he is not residing in the village where the sites are prepared. So that by taking advantage of it, the Khata of the property not with the Grama Panchayat, enter the name of my grandfather, grandmother's name. That my father purchased these two sites. By taking the advantage of that, my father is not residing in the village. Now by taking that, after the death of my grandmother.
How is repetition maintainable?
My uncles are trying to.
How is repetition maintainable for that? If you have an interstate dispute amongst you.
So the order passed by the government has been challenged before the Karnataka. So the against the order passed by the Karnataka, we filed appeal before the Villa Panchayat. So as against that order passed by the Karnataka.
Odi, what is wrong with that? Read what is wrong with that order?
The property purchased by my father.
Our ಏನಂತಾರೆ?
They are saying that it is that family property.
ಮತ್ತೆ?
No, my father is having.
He might have purchased, sir, but it's joint family property. How do we get into writ petition? ಹೆಂಗ ಹೋಗಕ್ಕಾಗತ್ತೆ ಅದಕ್ಕೆ?
So it is for them to file a suit for partition.
We are not here to say that. We are not.
So the writ petition is maintainable because the order passed by the government act.
Gram Panchayat has passed an order because there is interstate dispute amongst the family members. Point out what is wrong with that order.
There is no dispute.
Can the Panchayat authorities decide whether joint family property, absolute property? Read the reasoning, sir. Read the reasoning.
Panchayat has no jurisdiction to enter the Khata against the said executed in my favor. My father purchased the property, so Mr. said.
Then who has to enter the Khata? Who has to enter the Khata? Who has entered the Khata in this case? Dispute is before whom?
Dispute as against the order passed to the government.
You are not an appeal. You said that Panchayat has no jurisdiction. You said point out why it has no jurisdiction. Which is the order of the Panchayat?
They are issued this endorsement only.
Wodi. Read.
I have to copy at page 27.
Yes, read.
ಹೆಂಡತಿ ಚೆನ್ನಮ್ಮ ಅವರು ಭೌತಿ ಖಾತೆ ಮಾಡಿಕೊಂಡು ಅರ್ಜಿ ಕೊಟ್ಟಿರುವ ಮೇರೆಗೆ ತಮಿಳುನಾಡು ಗ್ರಾಮದ ಅವಶ್ರೇಷ್ಠ ಪುಸ್ತಕ ಸೊತ್ತಿನ ನಂಬರ್ 357 ವಿಸ್ತೀರ್ಣ ಪೂರ್ವ ಪಶ್ಚಿಮ 54 ಹೆಂಚಿನ ಮನೆ ಹಾಗೂ 358 ವಿಸ್ತೀರ್ಣ 40.
So you are saying Panchayat has no jurisdiction for this?
Panchayat has no jurisdiction to enter the Khata against the CID. Against the NPC, not suppose not. If the CID, who said it, some person purchases the property who said it. As against the said CID, they cannot enter the name of the Khata if they are some other person whose name is not shown in the CID. So the Panchayat has jurisdiction only to enter the Khata in whose favor the CID is situated. executed.
What happened to your appeal?
Appeal, the Taluk Panchayat rejected the
Appeal.
appeal.
Saying what?
And the government, so since it is, they are saying that it is that family property, so there being any authority of law, they cannot say. So say we die of produce, connection A. So to that say it not my father, but there is property. Sites.
Yes, read the order, sir.
Another
Read.
Taluk Panchayat order.
Yes.
Made it the operative was not
Yes,
there.
read page 35.
ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಗೆ ತೆಗೆದುಕೊಂಡು ಬೇಕು ವಾದ ನಡೆಸಲು ಈ ನ್ಯಾಯಾಲಯ ಅವಕಾಶ ಕಲ್ಪಿಸಿಕೊಟ್ಟ ನಂತರ ದಿನಾಂಕ 9/8/2011 ಮೊದಲನೆಯದಾರರು ಮೃತ ಹೊಂದಿದ್ದು ಈಗ ಅವರ ವಕೀಲರ ನ್ಯಾಯಾಲಯದಿಂದ ಒಂದು ಮೆಮೊ ಸಲ್ಲಿಸಿದ್ದು ಮರಣದ ಬಗ್ಗೆ ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. ಅದರಂತೆ ಮೃತ ಚೆನ್ನಮ್ಮಳ ವಾರಸುದಾರರನ್ನು ಕಡತದ ಮೇಲೆ ತಂದಿರುತ್ತದೆ. ನಂತರ ಎದುರುದಾರರು ವಾದ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಅಪವಾದದಲ್ಲಿ ಹಾಗೂ ತಕರಾರಿನಲ್ಲಿ ಹೇಳಿದ ಅಂಶಗಳ ಜೊತೆಗೆ ಮತ್ತೆ ಪ್ರಸ್ತುತ ಆಸ್ತಿಗಳು ಕಾಮಗಾರಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಗೆ ಸೇರಿದ್ದು ಅದರಲ್ಲಿ ಆಸ್ತಿ ನಂಬರ್ 350ರಲ್ಲಿ ವಾಸವನ್ನು ಇದ್ದು ಇದರಲ್ಲಿ ಕುಟುಂಬದ ಎಲ್ಲಾ ಸದಸ್ಯರು ವಾಸಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ಮೇಲ್ಮನೆಯದಾರರು ಕೂಡ ಅಲ್ಲಿಯೇ ವಾಸಿಸುತ್ತಿದ್ದರೆಂದು ಮೇಲ್ಮನೆಯದಾರರು ಹಾಗೂ ಮನೆಯದಾರರು ಉಳಿದ ಮಕ್ಕಳನ್ನು ಯಾವುದೇ ರೀತಿಯ ವಿಭಾಗಕ್ಕೆ ನಡೆಸಿದರು. ಈಗಲೂ ಸಹ ಎಲ್ಲರೂ ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿ ವಾಸಿಸುತ್ತಿದ್ದೇವೆ ಎಂಬ ಪ್ರಬಲ ಕಾರಣಕ್ಕಾಗಿ ದೇವರಾಜಯ್ಯ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಪ್ರಸ್ತುತ ಆಸ್ತಿಗಳನ್ನು ಮಾಡಿ ಅವರ ಜಮೀದಾರದೇವರಿಗಿದ್ದು ಅವರ ಪೌಷ್ಟಿ ಹಾಗೂ ಮೊದಲನೆಯದಾರ ಹೆಸರಿಗೆ ಬಂತೆಂದು ಹೇಳಿ ಸಲ್ಲಿಸಿರುವ ಅಂಶಗಳಲ್ಲಿ ಹಾಗೂ ಈ ಒಂದನೆಯದಾರರು ವಾದಕ್ಕೂ ಲಭ್ಯ ದಾಖಲೆಗಳಿಗೂ ಒಂದಕ್ಕೊಂದು ಮಾರಕವಾಗಿ ಕಂಡು ಬರುತ್ತಿದ್ದು ಒಂದನೆಯದಾರರ ವಾದವನ್ನು
How do we get into this, sir? How do we get into this? Establish your rights. Establish your rights. But petitioners before this court being agreed with the order.
My father purchased property.
Maybe so. They are saying it's a joint family property. Your rights are there. Once the dispute is there, we can't get into the dispute, sir.
Because the dispute is not, so it is for them to approach the civil court.
Whoever it is.
Not in the Khata proceedings. The Panchayat can enter the Khata in favor of the person in whose them the state is executed. So that Panchayat has no institution to go beyond the state or any document, right document.
When did he pass away?
Pardon?
When did he pass away?
8 months.
Khata stood in the name of Devraj.
I purchased property.
What's your name? What is your name?
My name is my father's name. D. Narayan. So my father purchased the
Khata stood in whose name?
Pardon?
Khata yaar hesru likho.
Not by taking advantage of the fact that my
Please
father
answer the
not
question,
taking
sir. Please answer the question. Before making the Khata name of Channamma, whose name the Khata stood?
in favor of the father of my
Your grandfather's name. Then you want this court to decide whether the grandfather has a right, whether the son had a right, whether the grandmother has a right in a Khata proceedings.
No, the question is
ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಖಾತಾ ಯಾವತ್ತದು ಇತ್ತಾ? ತಾವ್ ಯಾವಾಗ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರ? 72 purchase. Have you got the Khata in your name after 1972? Have you got the Khata since 1972? When did you die? You want all these issues. You want all these issues sorted out in writ proceedings. Admittedly, Khata stood in the name of your grandfather. Barkuli. Present petition is filed by the petitioner seeking following relief. It is the case of the petitioner that the subject property was purchased by their father in terms of a deed of sale dated 1972, produced at Annexure A. However, the Khata was in the name of their grandfather. For the demise of their grandfather, Sri Devarajaya, their grandmother Srimati Channamma made an application and the Khata was effected in her name as per Annexure D. Being agreed with the same, the petitioners had filed an appeal. By order at annexure M, the appeal came to be dismissed on the premise that there is a dispute with regard to the nature of the property in which the petitioners are claiming the property to the self-acquired property of their father, while the respondents are claiming the property to joint family property. The rejection of the appeal for the aforesaid reason has given rise to the present petition. The council so-and-so, reiterating the grounds urged in the memorandum of petition, submits that the panchayat had no jurisdiction to effect the khata in the name of Channappa, inasmuch as the father of the petitioners were holding the sale deed in their name. Since the sale deed is in existence, the panchayat ought not to have effected the khata in the name of Channamma. To appoint a question to the council in whose name the khata stood prior to the khata being registered in the name of Channamma. It is stated that the khata originally stood in the name of Devarajaya, who is the grandfather of the petitioners. Upon the demise of said Devarajaya, his wife Channamma made an application for registration of khata in her name. Though it is claimed by the petitioner that their father purchased the property in the year 1972, there is no piece of material evidence produced before this court to support their contention that the khata stood in the name of the father of the petitioner. Though it is claimed by the petitioner that the property is the self-acquired property of their father, in view of the dispute being raised with regard to nature of the property, the same requires to be adjudicated before a competent court of law. No infirmity or illegality can be found with the impugned order. Petition lacks merits, dismissed.
Number 23. You gave me the petition.
Finding the statement of.
How we, this case, and the entire order sheet, these are the order sheet.
What does this matter?
If the election roster again, in this case, May 2022, these are the quota. May 2022, and the scheduled time arbeit number, Mr. Mogasi. According to the host, mayor post or deputy mayor post is reserved. If they are not reserved for the third post. According to
The petition may not, it has been reserved for the SC.
Ah.
We have filed in statement of objection.
no, because tomorrow is elections. It is last occasion is also the 30th, 9, 2000.
Haley, what is the fact statement?
ST corporate.
Hmm.
After the ST corporate, there was no rotation for the mayor and deputy. I filed the petition before this court, and this legal system consider my application. According to that, this court is to be allowed my petition. Allowed my petition. Subsequently, the important of modified the PCA as a category. Then after in
2 minutes.
the order sheet is sent.
1 minute. Please, hold on. This is Shumaga.
ST woman 2016 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ according to this. 16 ನಲ್ಲಿ ಇವಾಗ ಬಂದಿದೆ.
So what does the guidelines say for you to say that you will in future will assign?
On rotation basis, it is for the.
No, you read page 7. On what basis are you making this statement? Gradually, reservation of the scheduled tribe category would be assigned in future.
On rotation basis, my lord, because we have done census in 2011. As per census, 2.
You have challenged this refixation of the reservation. You're not challenged.
Because page number 14.
No, they have refixed this reservation. No?
Not because the Abdul Aziz case is clearly stated 2.85 population. According to the Abdul Aziz case, it is a guideline to rotation issue minimum 2.85 is sufficient for the that guideline. 2.8 ಇದೆ. ST woman ಇದೆ.
No, 2.85 ಇದ್ರೆ ಏನು?
Population.
Correct. ಏನಾಗುತ್ತೆ?
0.5 ಇಂದ ಮೇಲೆ ಇದೆ. Reservation ಕೊಡಲೇಬೇಕು ಅಂತ ಹೇಳಿ
So now 2.85% is the population.
Population ಇದೆ.
of the ST. So ಆವಾಗ ರಿಸರ್ವೇಶನ್ ಕೊಡ್ಲೇಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ ಅದು? One second, ಕೊಡಿ ಅದು. Tomorrow is election.
Tomorrow is election. Last election.
You have filed your nomination. You have filed your
nomination.
nomination.
I am not eligible because it is chosen from SC.
Who are?
I belongs to SC. I am ST. I belongs to SC.
So what do you want in this case?
3 times SC or ಕೊಟ್ಟಿದ್ದಾರೆ.
No, what's your grievance now?
So challenging the postings for the ನನಗೆ ST reservation ಮಾಡ್ಕೊಡಿ ಅಂತ ನಾನು.
So you belong to ST category. Now it is reserved for SC category.
Now it is reserved for 3 times. 3 ಸತಿ ಅವರಿಗೆ SC ಅವರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. Page number 77 of the my petition.
Page number
77.
Yes. Yes, ಹೇಳಿ.
The office of the mayor and deputy mayor in the city corporation scheduled tribe, women and backward classes, for the subsequent terms to be determined by the government from time to time, taking into consideration such factors as being fit, provided that if the reservation workaround of any category less than 0.5%, then no officers of mayor and deputy may be reserved to such category.
Yes.
2.85.
No, it only says if it is less than 0.5%, there is no requirement of reservation.
Then the 2.85.
So ಎಲ್ಲಿ ಹೇಳಿದೆ ತಾವು ಹೇಳಿದಲ್ಲ 2.85 ಇದ್ರೆ ಕೊಡಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ ಇದರಲ್ಲಿ?
Because I produced it say 2011 census. 2011 census page number 25. Is out of government is also admitted 2.85% of population is there. But ST woman is once the 40.
SC population ಎಷ್ಟಿದೆ ಅಲ್ಲಿ?
SC population
This is the third time reservation, is it?
how is that time?
So tam prakarvagi, they say it has to come as per rotation.
No, ಅವ್ರಿಗೆ ಕೊಡ್ಲಿ ನಾವು ಮೂರನೇ ಬಾರಿ ಕೊಡ್ತಾರೆ. ಈಗ 2013 ನಲ್ಲಿ ಟ್ರಾನ್ಸ್ಮಿಷನ್ ಆಗಿದೆ ಶಿವಮೊಗ್ಗ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಅಲ್ಲಿಂದ ಇಲ್ಲಿಯವರು ಎಸ್ಟಿ ಅವರಿಗೆ ಯಾರು ಒಂದು ಸಹ ನಿಯಮ.
What is the population of SC there now?
SC is 12.6.
12.63.
ನಾನು ಇವತ್ತು ಕೊಡ್ಲೇ ಏನು ಒಂದು ವರ್ಷ ಹೋಗುತ್ತೆ. 90%.
No, you make some preliminary submissions. Pass over. How? On what basis are you giving? On what basis you consider rotation? Where's the government order?
ಒಂದು ಸಬ್ಮಿಷನ್ ಅಲ್ಲ.
One ನಿಮಿಷ ಹೇಳ್ತಾ ಇದಾರೆ. ಆತರ ಪಡ್ಬೇಡಿ, ಕೇಳೋಣ. Next year government order ಓದಿ, read the government order. Which is the government order? ಇದು ಅಂದ್ರೆ ಯಾವ್ದು ಸರ್?
ಈಗ ಅವ್ರು ಹಾಕಿರೋ ರೆಸ್ಪಾನ್ಸ್ ಎಸ್ಟಿ ಒಮ್ಮೆ ಕೊಡಲೇಬಾರದು ಅಂತಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಹಾಗೆ?
ಪೇಜ್ ನಂಬರ್ 14 ಆಫ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್.
ಓದಿ.
Category ST woman, there is no reservation for mayor or deputy mayor throughout the state. Because he was considered for 2011. Decreasing mode, how can he calculate without consent?
Now this is issued yavaga? 22nd January 2021.
No.
You are not challenged this.
I'm not challenging.
Then without challenging this, how can you ask them? You have to challenge this. You will have to challenge this. This is coming in a way. They are relying upon this. This is a government order. Rightly or wrong, this is a government order.
That's why in the last petition is also in terms of what is
I would have read the Elli, where is it?
29.
Ellipa, okay. Now you have done this. What is this annexure Arkuma? What is the annexure Arkuma?
Government order institution repetition and framework and government order.
So these are the guidelines based on which you have refixed now. These are guidelines. These guidelines have not been challenged so far.
I'm not challenged. Institution in the first application is also. In the first application,
no, is ಅಂದ್ರಾಗಲ್ಲ, is a gazette ಇದು. ಅವ್ರು ತಮ್ಮ ಕೈಲಿ ಕೊಡಬೇಕಂತ ಏನಿಲ್ಲ. This is a gazette. Sir, this is it's a gazette notification. You expect them to hand it over in your hand. And this is there. This is there from 2 years now. If in the light of these guidelines, in the light of existing guidelines,
2022 our coordinate bench is post is mandate ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಕ್ಲಿಯರ್ ಕಟ್ ಇದೆ ಸರ್. ನಾನು ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ. KCC 2022-4
ನೀವು ಹಂಗ ಹೇಳಿದ್ರೆ ಎಲ್ಲಿಂದ ತರೋದು ನಾವು?
ಸಿಗ್ಲಿಲ್ಲ.
ನೀವು ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ಮೊಬೈಲ್ ತಗೊಂಡು ಓದ್ಬಿಟ್ಟು ನಾವ್ ಎಲ್ಲಿಂದ ಸೈಟೇಷನ್ ತಗೊಳ್ಳೋದು?
ಸಿಗ್ಲಿಲ್ಲ, ಕಟ್ ಆಗಿದೆ. ಅದಕ್ಕೆ 230 ನಾನು
Where is the reference?
230 ನಾನು
This is for 1 year. You may have to take your chance next time. Calendar of events are issued. When was the calendar of event issued?
After
13/10.
during the
What is that you originally challenged the petition?
Why originally I challenged this?
What have you challenged in the petition?
From notification.
What notification have you challenged?
Annexure M.
Annexure? What is annexure M?
The page number 91. Eviction Shimoga is the notified as PCA and general woman.
Page number?
Page number 91.
Any notification?
PCA.
Read the notification, sir.
Government hereby allows officers, mayor and deputy mayor, various categories comes in respect of city corporation, 73 of the Karnataka.
Come on, notification is a reference to 21/1/2021 guidelines. And you say you don't know?
21.
You just made a submission. You did not even know the notification. Read your notification, page number 91. Please read that, sir.
Yes, Your
Please read.
Dated 21/1.
Read the entire paragraph. Please read the entire paragraph.
Government
Ah.
hereby allows the office of the mayor and deputy mayor
Ah.
to various categories for 24 and in respect of following city corporation under Rule 73 A of the Karnataka Municipal Corporation Amendment Rules 2020 guidelines issued by government order.
Ah.
UDD 264 ML.
That's your notification.
Yes, sir.
There's a guidelines.
It was also repeated. It repeat to all.
ನಾವು ಸ್ವಲ್ಪ ಕೇಳಿದ್ರೆ ಎಲ್ರಿಗೂ ಅವಕಾಶ ಆಗುತ್ತೆ. This is in the public interest. All right. Now, you said you are not aware of the guidelines of 2021.
Yes, sir.
You just made a mention now. This notification is issued pursuant to the guidelines. And you are not challenging that guidelines.
Anyhow, because of judgment ಇದೆ. Ordinary bench judgment ಇದೆ. ಅದು ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ತಾವೇನು
ಅಲ್ಲ ತಾವೇನ್ ಮಾಡೋದಲ್ಲ, ತಾವ್ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು ಮಾಡೋದು.
ಅಲ್ಲ judgment ನಾನು ಪಬ್ಲಿಕ್ ಆನ್ ಸಮಥಿಂಗ್
230 ನೋಡಿ.
judgment ಅದೇ judgment
The notification impugned in this writ petition is issued pursuant to the guidelines which you say you are not aware of. But your notification which you are challenging itself refers to that guidelines. ನೋಡಿ ಹೇಳಿ may not survive 230. Rectification of office of serve ಮಾಡಿಲ್ಲ ಅಂತನಾ? You are for the implementing application. ಏನು why you want to come and what is this matter?
The complaint my lord on my complaint the no confidence motion was moved and a notice was issued to the respondent the petitioner to have a meeting on 8/9/2022. That has been challenged by the
Notification
notice
notice
for no confidence.
that is challenge.
That is challenged.
ಯಾವಾಗಿದೆ?
So already over 8/9 is over, but my lord they now they
ಏನಿದೆ ನೋ ಕನ್ಫರ್ಮೇಶನ್ ಏನ್ ಆಯ್ತಾ? Have the proof the
but they will say my lord that it's not completed. Could not
there is a stay.
this is stay by the
ಕೊಡಿ ಆರ್ಡರ್ ತಪ್ಪು. ಆರ್ಡರ್ 12/9 ಏನು what is the defect in the notice? ಹೇಳಿಪ್ಪ ನೀವು ಹೇಳಿಪ್ಪ please you when you stand on your feet when you're making a submission please make submission merits also, otherwise you said that earlier. Make a submission merit, please go ahead. There is an amendment to the provision. The 30 months is not required, 15 months. ಅದು ಇಲ್ಲ 1/3 ಇಲ್ಲ ಅಲ್ಲ ಇವಾಗ. Yes. ಅದರಲ್ಲಿ ಏನಾದ್ರು ನೋಟ್ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮಾಡಬಾರ್ದು ಅಂತ ಹಾಗಿದ್ರೆ is there a condition that if a person belongs to a particular category being a sole member no confidence motion should not be moved anta idea? No, you are arguing, please argue. You raise the point, please answer the point. Really, read take the notice. Come take the notice Mr. Counsel, take the notice. Point out. Call Monday. Saturday.
29.
The one day category, she is elected in the reserve category. And now, if you adopt this method of no confidence motion and remove her from that category, what is the purpose of reservation?
But here is the case, my lord, she has already completed 22. The purpose is not that she has, there was a misconduct by her. That is main reason.
She was elected as a president for how many? What?
It was in the 2021, she was elected. Now almost completed 22 months. Now only 6 months is there. But she did not, she is in, indulged in misconduct. That's why the no confidence by 9 members have been moved. I think. Now the 9 members are the.
How many members total?
Total 11 members.
230. 230. Yes.
During the night, number 25. You can tell them.
I appear for the first respondent, my lord.
Yes. Any objections on IA 1, 2, and 3?
I have no objection.
Who's respondent number 2?
Private party. Is a private party, notice has to go to the LRs.
Notice ಹೋಗಿದ್ಯಾ? ಎಲ್ರಿಗೂ ಹೋಗಿದ್ಯಾ? Accepting the cost shown in the affidavit accompanying the application in IA number 1, 2, and 3. IAs are allowed. Petitioner is permitted to bring the LRs of deceased respondent number 2 on record. Petitioner to amend the cost title and file the amended cost title within 2 weeks. Yes.
26. You was there in that case.
R5 and R6 are received. No, I have made application for removing the lot of R6 on record. So I came to know by virtue of the sale dated 14/7/2022. R5 is also there. These children have
2 weeks at the request of the counsel of the petition.
27.
No, the idea on here was stationary. But the idea is not to down even. There is some urgency in this case. We can take up tomorrow.
You are for the petitioner. He is saying for petitioner.
Intervention application.
You are for the petitioner. We are asking the question to him. Let him answer, no? Right or wrong? Whom are you appearing for?
I am appearing for the respondent. For this, I am filing this intervention application.
Huh.
In this, I have filed for, they have an intervention. I have filed and I am for vacating the intervention.
Who are you? What is this matter?
This is pertaining for fish market.
Huh?
So I am actually with, the corporation has never granted permission to establish stalls in within a fish market. So subsequently there is a other notification. Subsequently there is a notification stating that other than people who are permitted, the unauthorized stalls needs to be vacated. So this is the crux of the matter. But
Who are you? What's your interest in this petition?
because I am appearing on behalf of respondent number 3.
Well, you say some intervention and all.
I have filed memos for vacation of the intervention.
Huh.
There is some urgency. Maybe.
Really? We are ready to hear.
My colleague will be.
Next week.
There is urgency.
We are ready to hear. Next week. Interim order granted earlier. Next week.
What number?
Yes.
28.
Not, this is a matter where the road photograph may not be allowed to sort for some time.
Construction of wall on the road.
Construction of road has been stalled. He's saying that it's government land. He's saying he's an unlawful occupation. He sought regularization. That regularization has been rejected by the government. Now, my lords, what portion portion I'm asking, that portion is not coming anywhere near a residential dwelling. My lords, it is 3 meters away from his residential dwelling. He's saying that the entire extent of 7.13 cents, he is in unlawful, he is in occupation of the same, and therefore we cannot do anything.
Fencing part.
Fencing, yes, exactly. No, there is no fence.
Where's your fence? It was in a dilapidated condition last time.
So just for the latest photograph, watching my friend to see the photographs. I think we were 5 and 6 and 7. 6 and 7.
No, we're not able to make out anything from this
My
photograph.
lords, if I can just quickly take my lords to page number 6 for a minute.
Photograph.
Photograph. Just take first photograph shown. If your honor see the first photograph.
Yes.
This is from one side of the road. What your honor is seeing as the mud portion for me.
That's the scooter in the
Scooter in the solpa munde muddy portion is for me.
Yes.
The scooter in the full extended portion road is. The muddy portion trees are cancelled for me. That is where we want to expand the road.
There's a pole, electric pole in the corner.
Yeah, electric pole in the corner. We are not touching that side. We are expanding on the other side.
So you want to cut it through.
Cut it through. If your honors now turn over to the next page, if your honors just turn over to the next page, your honors will see that already there is a road on the other side. Our side, a gap a bit where the petitioner's property is situated on the left side. I show your honors the petitioner's property also. Then if your honors now turn over to the next page, it's a little bit better. If your honors see, portion.
There's a small portion protruding.
Yes, this all I'm asking, e portion away, and that is not going to touch the petitioner's property at all. If your honors now turn over, if your honors see there's a pakka road everywhere, just one.
Yes.
This, if your honors turn over now to the next page, at page number 6 one. This is the petitioner's house. It is situated 9.13 meters
You
from
must
the.
advise your client. You must advise your client.
They say that my application for regularization has been dismissed by the common order dated 1811.
How did you get this property?
I am unauthorized occupant, no doubt that. Yes, my lord, this extent of land, let them give my lord, but my liberty to challenge this order, 1811 order.
Which order?
Nandu statement of objection, Nandu statement of objection.
Annexure?
R5 is at page 30, 28, 28.
So you are in admittedly unauthorized occupants in the property.
But my application is pending.
For regularization, which is the order passed by rejecting annexure?
Page R5, page number 29, serial number 12, serial number 12, Srinivas Bin Damu Alapik Arjit number serial number 12.
Yes.
But for the remaining extent of land, my application will be continued.
Stay, the road alignment will continue. Whatever property you have, however you occupied, you regularize or do you have all the rights. Don't obstruct for the formation of road.
Even if I'm another document, but whatever improvement there on the part they are going to acquire for on the road, which they may not.
You prove your authorization first.
After he makes the question, I just want 2 minutes, I want to point out.
Yes, Shel. Yes.
The owner or occupant of the demand is prove that any situation involving or obstruction has existed for a period sufficient under the law of indicated agreement of distinctive title. Or where such period is less than 30 years.
All that is available to you, sir. It's not just naturally you are entitled for it.
That is what I want.
That goes without saying. You are not entitled by fault, there is no strict liability on their part to make the payment unless you establish your right in accordance with law. That is available to you. But present petition is filed seeking following reliefs. case of the petitioner is that he has been in possession and enjoyment of the involved property described in the schedule to the petition since 1980. So that he has constructed a residential building and is in possession and enjoyment of the same. The extent of the settled property is 7.13 cents. That Hakkupatra kottidara?
So that is the thing. I just want to clarify one thing. What Hakkupatra has is for 600 square feet of land.
Correct.
Then,
ಅವರು ಅದೇ ಹೇಳ್ತಾರೆ.
now he's saying 600 bittu, I have asked for regularization of 1200. That is prohibited under section 96.
That is
the reason I'm saying.
We are not on that. We are not on that. It is further case the petitioner that a Hakkupatra in respect of portion of the scheduled property has been issued covering the residential building in terms of order dated 31/10/1995. That ever since the grant, the petitioner has been in possession of the scheduled property as a grantee. That he has also made an application dated 7/8/2018 seeking regularization of the portion other than the one mentioned in the Hakkupatra.
Only 1200 square feet. Total portion is 3100 square feet. He sought for regularization of only 1200 square feet. Additional 600 square feet.
He has sought for regularization of certain portion of the scheduled property. That there is a public road, Kulashekara-Kannagudde Road, having width of 20 feet, running on the southern side of the scheduled property. And the respondent number 1 has metal about 12 feet portion of it, and the remaining mud portion on the either side is presently being used as a road margin. There is a rain drain of about 2 feet width on the northern edge of the said road. With the respondent commenced work of widening the said Kulashekara-Kannagudde Road during the year 2000, during the last quarter of the year 2021. And in the process, the petitioner respondent is taking over the property in occupation of the petitioner. The petitioner, being in possession of the suit property, had approached the civil court in OS number 216 of 2021 seeking relief for permanent injunction. And there was an interim order injuncting the respondents from interfering his peaceful possession. In this petition, full stop. There was also proceedings before subdivisional magistrate under section 133 of the Criminal Procedure Code. Since the petitioner filed the present writ petition, the aforesaid suit and the proceeding before the subdivision magistrate withdrawn. Full stop. That the land, any portion that the respondent do not require any portion of the scheduled property for the purpose of widening of the road However, the respondents are acting at the behest of certain persons with vested interest to deprive the right of the plaintiff petitioner over the scheduled property. Hence the petition. Objection statements have been filed with the respondents denying the petition averments and contending that the petitioner has been in unauthorized occupation of the scheduled property and the Hakkupatra was only in respect of Hakkupatra ಎಷ್ಟು sir? 600 square feet. In addition, the petitioner has sought for regularization of only 600 square feet of land, another 600. Therefore, the claim of petitioner being in possession of 7.13 cents of or about 3,100 square feet is fallacious. So the request of the petitioner to regularize his unauthorized occupation has been rejected in terms of order at annexure R5 on 18/11/2020, wherein at serial number 11, serial number 12, application filed with the petitioner seeking regularization of land has been rejected. Thus, it is submitted that the petitioner, in the first place, not having any right whatsoever over the land, more particularly his requisition having been declined, has no locus standi to maintain the petition. The present petition is causing impediment in the process of respondent widening the road, further causing hardship to the road users and general public. Hence seeks for dismissal of the petition. Heard and comes for the parties, peruse the records. Though the petitioner claims to be in possession of 7.13 cents of land, admittedly he has been given Hakkupatra to an extent of 600 square feet of land. It is also not in dispute the petitioner has sought for regularization of another extent of 600 square feet of land, which application has been rejected by the respondents at annexure R2, as per annexure R2 referred to here and above, R5 referred to here and above. Good start. Now it comes for the petitioner referring to section 287, class 2 of the Karnataka Municipal Corporation Act 1976 submits that notwithstanding the fact that the petitioner is in unauthorized occupation of the land, his rights for adequate compensation cannot be denied. Good start. He further submits that the rejection of the requisition of the petitioner seeking regularization is subject to challenge and his right to that extent be reserved. Full stop. He further submits that the said order has not been served on him. Submission taken on record. In view of the admitted facts of petitioner having been issued Hakkupatra to an extent of 600 square feet of land, and also in view of admitted fact of petitioner having sought for regularization of additional 600 square feet of land, the claim of the petitioner to an extent of 7.31 cents, 7.13 cents prima facie does not appear to be acceptable. However, reserving liberty to the petitioner to seek remedies which he is otherwise entitled under law. Full stop. It is directed the petitioner shall not cause obstruction in respondent widening the road as shown in the photograph at annexure. Photographs produced along with the memo dated 2070 to align with the widening of the road, which is already taken on the either side of the property shown therein. Full stop. Subject to the above, petition is disposed of.
I have specifically stated the details of what is the extent required in the statement of the petition.
Hit. Adun Barshili. As per the respondent, the
So paragraph 9 of the statement was mentioned.
the respondent in paragraph 9 of the statement of objection has stated about the requirement of the land for the purpose of widening of the road. The widening of the road shall take place as per the requirement of yes.
Number 29.
20. What is the matter?
The order challenge. The petitioner may not have reflect constantly. Complaint was filed by the petitioner number 1 there, next D page 70. Before the deputy commissioner, seeking for disqualification under the Prohibition of Infection Act 1987.
Prohibition of?
Infection Act 1987. The petition came to be allowed. The order is at Annex D, page 70.
Yes.
The proposed respondent now, who seeks improvement, was a contestant to the post of president of the town municipal council. He unsuccessfully contested. He was not a party before the proceedings before the deputy. Therefore, he is not a necessary party before this.
Your requisition for disqualification, what happened to that?
The disqualification petition was allowed, which has been stated by this one.
Disqualifying you.
Disqualifying all the petitions.
At whose instance the application was made?
One Mr. N.R. Ramesh, who is arrived as respondent number 3 in the report.
Already you have read it.
I have already. Proposed respondent number 4 unsuccessfully contested along with one of the petitioners for the post of president, town municipal, city municipal council council.
Yes, how does it matter for you?
The party mandate, as one party advice, contested for vote. So, 14. Petitioner violated the party deed. So the disqualified of the petitioner was. So petitioners.
Petitioners and you belong to same party. Petitioners and you belong to same party. So you have disobeyed the whip.
That is what they say.
All right. So who is the respondent number 3?
Respondent number 3 is the complainant before the authority.
He's also same party.
He is the president of the Bangalore South District of the Bharatiya Janata.
Same party. So what difference does it make between you and the third respondent? What difference does it make, or what better can you make by coming on record when the third respondent is already on record? All right. So how does it affect your right? Complaint is filed. That's a different issue. The question here is they have been disqualified at the instance of third respondent. Third respondent will be heard. You remain silent all along. It's not going to affect their qualification, disqualification is not going to affect you in any manner. All right, we'll consider it along with the name. Is this matter for hearing? Interim order granted earlier extended till next order hearing date.
14 November.
14 November, we hear. The big group. Yes. Big group.
Preliminary matters, number 30. The Karambaya.
Allotment of site. You paid 7,000 rupees. 2,000, 5,000 you have paid. Why have you cancelled it?
Mysore City Corporation.
Muda. First tamdidiyalla. State of Karnataka Urban Development Department ide. So tave heltare ade agutte. Why have you cancelled it? Yes, the DGA to take note, direct note, the DGA take. You make them to withdraw it, they withdrew it, then you turned around. Adagi agirodu. The writ petition filed, they asked her, we'll consider your request, withdraw the writ petition, they withdrew the writ petition, withdraw. Allow AG to take notice to respond number 1, issue notice to respond number 2 and 3. Counsel for the fifth. Yeah, idara? Vivekananda is directed to take notice for respond number 2. 3 are told that Tassidar. Our told that. Yes, Vivekananda take 2 and 3. Petition counsel to serve the court petition along with the annexure. Yes.
31, this is the Shivaram Bhattu.
Hague, sale deed cancellation writ petition.
I mean, we permitted to leave those there because once allotment is cancelled, consequences the.
You see, your case is of 55Q.
Yes,
55R is what the sale deeds have been executed.
no, now sale deed is executed on 55 or Q.
Correct. No, 55R is yours.
I am waiting.
Correct. 555Q is their side.
Yes.
Identification or not is inconsequential. You seek your remedy if you're entitled to. You are still in the lease come agreement. You are still in the inferior right. Maybe so. That R. Mohan and all those people.
There is no such thing at all.
That is different. We can't get into that. See, first you establish your right. You are given lease come sale agreement. You not got the sale deed allotted in your name yet. In the meanwhile, you got the wills also executed.
These companies have been approaching this party for after a period of 15 years, for which authorities are not responding. Therefore, I also.
We will not say anything more than this. Your prayer for cancel and sale deed will not serve.
Yes.
We leave it to you.
Yes. So far as cancellation of the sale deed is.
Nodi yen ಮಾಡ್ತೀರಾ ಮಾಡಿ.
No, in fact, for that period, there is.
ಕೊಡಿ.
In this case, there was a contract here. In my case also, there was a contract. That is lease from sale deed. Because what PTC after the constitution maintained the disputed question of fact involved. Held in an appropriate case, this court has jurisdiction to obtain a decision involving disputed question of fact. As there is no absolute warrant in this regard, therefore, verification involving series with the serious disputed question of fact requires computation of the origin, not on the court. Will normally be maintained under Article 256 of the Constitution. However, it has even been held that in a writ petition, if the facts require oral evidence can be taken. So, when the disputed income fact pertaining to the petition, meaning of the documents or part thereof are involved, and the court can very well go to the games and decide the petition if facts permit. Moreover, merely because one of the parties wants to the meaning of the document or part thereof, does not make a disputed fact. So, kindly turn to page number 557, paragraph number 557.
The facts are different, sir. There was an agreement in this case. The difference is no. Your case, please appreciate. Correct. See, as regards your requisition, with regard to execution of a sale deed, you may be entitled to. But that does not give you right to seek cancellation of a sale deed in respect of different property in favor of different person. That is different. Not fully. You may be entitled for representation for the purpose of consideration of granting.
And challenging the order of Annex A. If the election goes, Annex A goes to court. Rest of the things were not entitled for the delay. Because.
Annexure A itself is that's amounts to execution of sale deed.
The earlier, there was pending with there was no existence of 555 RQ. Therefore, the Buddha themselves allotted some alternative state. for having realized that 555 is not available. Now, after execution of the statement, they don't get 555 is not available. Now, again, after 10 years, we got 555 came into existence and allotted in favor of the third party. And now they are coming in the way of money type. And the second wave, directing the Buddha to execute a sale in my power in respect of 555. Now there is a clear finding, you want to find this thing. Their own document clearly shows that the sale is not available. Once they come to the conclusion that there is no sale.
Which is the suit?
Suit that the allotment of 555 or 2, yes, by the suit, 1286.
Where is the finding regarding identity of the property there in the suit?
Yes.
There is no issue in that suit.
Yes, Third, election fee, you asked.
Come to page 97.
97, that is suit. And after the dismissal of the suit, my lord, so Buddha, there is a fee should allot to the state of 114. 114.
Yes.
ಮಂಜೂರಾತಿ ಬದಲು ನಿವೇಶನಕ್ಕೆ ಮುಖ್ಯ ಅವಧಿಯನ್ನು ನಿಗದಿಪಡಿಸಿದಾಗ ಈ ಪ್ರಾಧಿಕಾರದ ವತಿಯಿಂದ ನಿಮಗೆ ವಿಜಯನಗರದ 2ನೇ ಹಂತದ ಬಡಾವಣೆಯಲ್ಲಿ 80-120 ಕೋಟಿ ಅಳತೆ ನಿವೇಶನಕ್ಕೆ 567 ಫಾರ್ ಬಿ ಅನ್ನು ಮೊದಲು ಅಂದರೆ ದಿನಾಂಕ 11/8/80 ಮಂಜೂರಾಗಿದ್ದು ಸಿಡಬ್ಲ್ಯೂ ಈ ಕೊಪ್ಪಲು 3ನೇ ಹಂತದ ಬಡಾವಣೆ ನಂಬರ್ 555 ಬಾರಿ ಕ್ಯೂ ಭೌತಿಕವಾಗಿ ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ ಬದಲಿಯಾಗಿ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ. Then clear finding by the authority themselves that 555 are this is 1999. Now in the year 2021 they are not 555 are two. And again, I know are two in last automatically.
So why do we get into the fact or a dispute whether the 555 Q?
No, nobody.
So then you go and ask. You ask 555 R.
Therefore, I will put this on.
No, Mr. Counsel, please appreciate. There is no one here disputing your entitlement of 555R site. Has anybody said that 555R5 is not existing? Then why should we assume something which is not existing? That we will not give finding. You seek your entitlement of 555R is there. Nobody is disputing that. That is not our headache. ಅದು ನಾವು ಹೇಳಕ್ಕಾಗಲ್ಲ. ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಮಗೆ ಸಿಗುತ್ತೆ. Sir, please, we are not in disagreement with you that 555 by Q is not in existence. Your claim is 555 by R. When nobody is disputing 555 R, why should we get into the fact 550Q or not? We don't know the purpose and intent.
Let them come and say before the court that they have, if Muda is to come before the everything.
They have already said that 555Q is not existence. What else you want?
Again, my lord, therefore I am before your audience. Again, if they say, my lord, 555Q is not available. Now, annex A, you are not paid this, my lord. Again, Manjura election A, my lord. Column number 4, you are not paid this. Manjura evasion 555Q, and how you put on that.
Show from the material that 555Q and 555R one and the same. Torsi.
There was there was page number 108. For 5.
Yes.
108.
Yes.
555 bar R. ಅದು ನಮ್ದು.
ಸಾವಿತ್ರಮ್ಮ. Yes.
555 bar B.
ಸುರೇಶ್. ಹೌದು.
ಆಮೇಲೆ ಈ ಕಡೆ ರೋಡ್ ಆ ಕಡೆ ಕ್ಯೂ ಸೇಮ್ ರೋಡ್ ಕ್ಯೂ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದು ಇಟ್ ಇಸ್ ಎ ಮಾರ್ಜಿನಲ್ ಲ್ಯಾಂಡ್. ದೇರ್ ವಾಸ್ ನೋ ಸಚ್ ಸೈಟ್. 50-120 ಇದ್ದಾರೆ. ಇಟ್ ಇಸ್ ಎ ಮಾರ್ಜಿನಲ್ ಲ್ಯಾಂಡ್. that marginal land 555 ಬಾರ್ 555 ಬಿ ಅವರು half of they are entitled. ಇದನ್ನ ಈ 20-30 ಸೈಟ್ ಅನ್ನ 50.
No, where does this document say 555Q is not existing and 555Q and N are one the same? ಎಲ್ಲಿ ಹೇಳ್ತಾ ಉಂಟು? We are asking only that. We can't assume. No, we don't know the intent of the petition. You have to be very clear. You point out from the records that the authorities have allotted your site 550 by R, claiming it to 550 Q Torsi.
They don't give me. But my problem is, now, what kind of way?
This annexure M goes against your case. That goes against your case. Report of the commissioner. He shows existence of all the three sites.
They have marked only two members. They say that therefore this should be able to dismiss. In the earlier suit, that was the finding.
Keeping open the issue of maintenance of the petition with regard to prayer number 1. Issue notice. To the respondents. Yes. That you still have to convince. No, you still, no. That's why you said prayer number 2 you may be entitled to, not prayer number 1. So keeping up. Up to you. If you will not do anything. Keeping open that question. You may be entitled to prayer number 2, not 1. Yes. Otherwise, the writ jurisdiction will be civil suit. Yes. Yes.
33.
Really, sir, you have taken the time last time itself. Point out how are you entitled for the relief of compensation of 2 crores and 1 crore for demolition of the property. Please point out. No, you have to Haley. Now you took the time. Aste Haley, how is the repetition maintainable? Your property was demolished. So please point out where is the strict liability attributable to the state that they should pay the compensation asked by you. Please point out that. Simple question of law. If you can point out there is a strict liability under so and so provision, they should pay the compensation of 2 crores and 1 crore for demolishing your business place, we will grant you the compensation. Haley, Berkule, you are entitled to have your remedy under the civil law. We'll keep it open. Act demolition
Compensation approach they have done. Damage word.
ಏನಿದೆ ಹೇಳಿ ಪಾಪ ಇವಾಗಲೇ ಓದಿಪ್ಪ ಇವಾಗಲೇ ಓದಿ ಹೇಳಿ read we will wait for you read your grounds ಬನ್ನಿ page number 10 ಗೆ ಬನ್ನಿ read ಅಷ್ಟೇ ಇರೋದು ಓದಿ ಹೇಳ್ಬಿಡಿ ಹೇಳಿ why did they demolish the property? ನಿಮ್ದೊಬ್ರು ಮನೆ ಹೋಗಿದ್ಯಾ ಪಕ್ಕದಲ್ಲ ಹೋಗಿದ್ಯಾ? ನಿಮ್ದೊಬ್ರು ಮನೆ ಮಾತ್ರ ಬಂದು ಡಿಮಾಲಿಷ್ ಮಾಡಿದಾರ ಆ ರೋಡ್ ಎಲ್ಲರೂ ಮನೆ ಡಿಮಾಲಿಷ್ ಮಾಡಿದಾರ ರೋಡ್ ವೈಡ್ನಿಂಗ್ ನೋಟಿಫಿಕೇಶನ್ ಇರ್ಬೇಕಲ್ಲ ಇದು ಅಕ್ವಿಸಿಷನ್ ಬರೋದಿಲ್ಲ ಇದು it's your petition. They request the counsel of the petitioner list this matter Saturday finally. Your claim is not that, sir. Your claim is because you suffered business loss. That's your claim. That's why you're asking 2 crores and 1 crore, not because of the acquisition of land. Both petition in Sala.
In the B group matter, number 34 and 35, they are Gopal.
But I appear for the petitioner, my lord, in this case.
Yes, Srinivas.
This is under the,
Pollution control.
yes, my lord, your lordship may kindly see, my lord.
Yes.
My lord, the respondent number 1 and 2, father is no more, my lord, the respondent number 2 is there. He is running, my lord, an industry in large scale, my lord, producing banana chips. And there's a hurling unit also, my lord. It is causing lot of nuisance. I am a neighbor, my lord. My lord, causing lot of nuisance. Annexure, my lord, L, my lord, kindly see, my lord. My lord, there has been several correspondence, and Panchayat has issued notice. My lord, as per annexure A to L and K, my lord. L, my lord, your lordship may kindly see. Pollution Control Board, my lord, on examination of the spot, my lord, on spot inspection, they have found, my lord, this is the, my lord, your lordship may kindly see, ಮೇಲ್ಕಂಡ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಶೃಂಗೇರಿ ಪಟ್ಟಣದ ಭಾರತಿ ಬೀದಿಯಲ್ಲಿ ಎಂಇ ಸುಬ್ರಹ್ಮಣ್ಯ ಚೇಷ್ಟಿ, ದಟ್ ಈಸ್ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡ್, ಇವರು ಚಿಪ್ಸ್ ತಯಾರಿಕಾ ಕಾರ್ಖಾನೆಯನ್ನು ನಡೆಸುತ್ತಿದ್ದು ಅದಕ್ಕೆ ಗೇರು ಸಿಪ್ಪೆಯನ್ನು ಉಪಯೋಗಿಸುತ್ತಿದ್ದು ಅದರಿಂದ ಹೊರಡುವ ದಟ್ಟವಾದ ಹೊಗೆಯು ಅವರ ಪಕ್ಕದ ಮನೆಗೆ ದೂರದಾರರ ಮನೆ ಆವರಿಸುತ್ತಿರುವುದಲ್ಲದೆ ಅವರ ಮನೆಯ ಹಿಂಭಾಗದ ಕುಡಿಯುವ ನೀರಿನ ಬಾವಿಗೆ ಕೊಳಕು ನೀರು ಬರುತ್ತಿದ್ದು ಪರಿಸರ ಮಾಲಿನ್ಯವಾಗುತ್ತದೆ.
How can they live there?
We can't leave, my lord. It is a thick smoke, my lord. Cashew sippe is used. My lord, there is a finding also, my lord. They have not taken.
I appear for the respondent number 3 in this matter, my lord.
Yes, have you issued the permission to them?
Afterwards, after these notices, they have taken steps to, they are not using the cashew sippe, and thereafter they are every day they are removing the this waste from the shop, my lord. That
No.
And in the same
Who will
issue,
watch up? Who will keep guard of all that, Mr. Counsel?
yes, my lord.
Who will keep watch of all that in the process?
No,
Whether
that has been watched after say the annexure, as per annexure L, we have been directed to monitor this at page 2 of that document, my lord. Shall I read?
Yes.
ಸದರಿ ಘಟಕಕ್ಕೆ ಉರುವಲಾಗಿ ಗೇರು ಸಿಪ್ಪೆಯನ್ನು ಉಪಯೋಗಿಸುವುದರಿಂದ ಹೆಚ್ಚಿನ ಹೊಗೆಯು ಹೊರಹೊಮ್ಮುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಹಾಗೂ ಘಟಕದಿಂದ ಬರುವ ತ್ಯಾಜ್ಯ ವಸ್ತುವಾದ ಸಿಪ್ಪೆಯೊಂದಿಗೆ ನೀರು ಪಕ್ಕದಲ್ಲಿರುವ ಬಾವಿಗೆ ಸೇರುವ ಸಂಭವವಿರುವುದರಿಂದ.
Now the license is issued for what period?
ಘಟಕದ ಮಾಲೀಕರಿಗೆ ಗೇರು ಸಿಪ್ಪೆಯನ್ನು ಉರುವಲಾಗಿ ಬಳಸದಂತೆ ಹಾಗೂ ತ್ಯಾಜ್ಯ ವಸ್ತುಗಳನ್ನು ಸಂಗ್ರಹಿಸಿ ಸೂಕ್ತ ರೀತಿಯಲ್ಲಿ ವಿಲೇವಾರಿ ಮಾಡುವ ನಿಬಂಧನೆಯನ್ನು ವಿಧಿಸಿ ಉದ್ದಿಮೆ ಪರವಾನಗಿಯನ್ನು ನವೀಕರಿಸುವುದು.
Correct.
So these are the directions given to us, and we have renewed it, my lord, on this basis, and he's been watched with regard to the violations.
Now,
and I would like to bring one more aspect in this matter, my lord. The petitioner purchased the property in the year 2007, and this unit has been running since more than 30 years. There is a dispute between them with regard to a passage between the two houses, my lord, the petitioner's house and the respondent number 1 and 2's house. They filed suit on the similar lines in OS number.
You are for?
Yes, my lord.
You are appearing for?
I am appearing for respondent number 3.
Authority.
Yes, my lord.
That they will argue, why are you taking their case? Why are you holding their brief?
Lord, your lordship may kindly.
Why are you holding their brief, Mr. Counsel? That shows something else.
Lord, this is.
When did you issue the license? 1 second, Mr. Counsel, please. When did you issue the license? What is the date of issuance of license?
I have to ascertain, my lord.
Where a period? Where is the license? When was it issued? When was it renewed? Akil Batavino.
So his son is busy with his father's ceremony issues. And we have to obtain.
No, we have all the sympathies for that, but the matter is pending since 2014. We are in end of 2022.
After obtaining necessary license.
You have not placed a single paper so far. Interestingly, the Panchayat seems to be taking your brief. You show when was the license issued and when was it renewed? When was it last issued? Kodi one noda na. When was it last issued?
It is also. Training lights. I think from the concerned authority, that is,
Now, first of all, can this kind of industry be run in the place like that?
the 24 hours run of industry. ಅವರು 30 years ಅವರು handmade ಇದು ಚಿಪ್ಸ್ ಇದು ಮಾಡ್ತಿದ್ರು ಆಮೇಲೆ ಇದು ಮಾಡಿದ್ರು ಅದು it is in the first floor. With modified intention after unsuccessful in the both the roads with new theory they have filed this up. Sorry,
All right, file your objection. Counsel for the respondent 1 and 2
judgment also.
seeks 2 weeks accommodation to file the statement of objection. Matter is pending since 2014. 2 weeks finally to file statement of objection, if any.
The sixth respondent, my lord, the pollution control board. My
Ah.
lord, Gachimut appears. I don't know, my lord, now who is appearing for pollution control board?
Letter ಕೊಟ್ಟಿದ್ದಾರೆ,
ಯಾರಿದ್ದಾರೆ ರೆಸ್ಪಾಂಡ್ 6 ಗೆ ಯಾರಿದ್ದಾರೆ ಇವಾಗ? Who is appearing?
ಇದು ಮಾಡ್ತಿದ್ರು.
ಅದೇ ಬೇರೆ ಯಾರಿದ್ದಾರೆ ಇವಾಗ? Joshi. Sri Gururaj Joshi is directed to take notice to respond number 6 in view of demise of Sri Gachimut. Counsel was appearing for the respond number 6 as earlier. Yes.
With much obliged.
Yes, yes. Let go.
14 now.
Kodi objections haki serve ಮಾಡಿ in the meanwhile. Yes. ಅದು ಕೊಟ್ಟು document.
Date, my lord.
14 November.
14 November.
Yes.
ಇದು ಕೊಟ್ಟು ಅದು ವಾಪಸ್. Passed over.
There are several notifications and also written communication, which I need to produce. I have just received it on my WhatsApp. Logic and I will post it next week. I'll produce all the publications, which will throw some light on the.
What publications?
That the commissioner is authorized to make amends.
He cannot do on his own. It has to place before the corporation. Corporation for to pass a resolution. Then it has to place with the government. Government should sanction it. That's all. You cannot on your own in a one the fine day get up and say that we will not allow this to happen. Where are those things?
I've received a letter from the WhatsApp. I'll go to the payment.
At the request of the counsel for the respondent, BBMP, to comply with the order of furnishing the details. Date
9th October, 9th November.
9th November. Yes. ಆಗಿದೆಯಾ ಆ ತರ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆಯೇನು?
Agide. There is a letter notification issued by the government authorizing the commissioner to make amends to the schedule.
Government governor notification not required. Act itself provides.
Yes.
But the commissioner has to follow the procedure contemplated there. How do? Act provides the commissioner to issue and add and delete schedule. But there is a procedure contemplated, whether those procedure complied with.
Yes, yes. It has been other there was notification, especially during the period of COVID. There were certain notifications which were also published. I'll produce the same.
No, this is submission for the sake of submission without looking into it. Anyway, look into it.
December 30th.
That is not matching with the requirement of law. Adhik heli, note to. Yes. Yes. Who is this party in person ಇದರಲ್ಲಿ?
I think the person who was finally is very
ಇದಾರ ಬರ್ತಿದಾರ ಅವರು? Has he ಕರೀರಿ ಕಳ್ಸಿಪ್ಪ. Where is the P1? ಕೊಟ್ಟು ಇವನಿಗೆ. Because they'll not be knowing, so inform them whether they have gone before.
And in fact, I have also filed a written submissions to the.
Have they appeared before the committee, 14% committee? Have they taken the certificate?
In this case, 3 times advocates have been nominated.
Adike, have they appeared? Have they appeared before the committee, 14% committee? I'll appear agidara. No. Even the pendency matter also they should appear before the committee. Accountability has to be fixed under the new rules. It is growing. That's why we'll see that. We'll inform them. The application, the order sheet is. Please. Or you can please call. We'll pass over. Or inform them. If they have not appeared before the committee, they should appear before the committee, satisfied that they will assist the court. Ask them to note. Then we'll take up, permit them to appear. They will not appear, permit them. Keep them present. Pass over.
With the Shankar Reddy.
Yes, please. Please.
First, the subject matter of land is land varying survey number 71. New survey number 114. Measuring 2 acres front, 2 acres.
2 acres.
2 acres. Total Dana finding this, the full of the Maroka.
Yes.
But it was granted not in favor of father of the college 4 to 8. But it was for an upset price. The grant was on 30th November 1963.
Yes.
Upset price not came to be paid on 20th January 1964.
Yes.
But the first sale has taken place on 12th January 1968.
68.
But proceedings before the Assistant Commissioner came to be initiated during the year 2006-2007 by L&D SCST 14 of 2006-2007 for the Assistant Commissioner Kola.
Yes.
The Assistant Commissioner Kola along the petition by order dated 29/7/2015.
Yes.
Appeal before the Deputy Commissioner was under RA SCST 4 of 2015-16.
Yes.
And the RA appeal came to be dismissed on 24th January 2018.
Yes.
Challenging both these orders. But Your Lordship, okay. From the date of sale, there is substantial delay from 1968 till 2006.
Yes.
There is substantial delay. But however, this one report wanted clarification on 2 parts. But what would be the case? In case not the property is granted for an upset price, whether the period of non-alienation is applicable even in those cases. Second aspect is not this particular grant has been made in the year 1960 and sale has taken place on 1968. So it is a period of 5 years. Whether the limitation point not to cover these cases also. But they were able to lay the hands on the judgment of the office of the court, not the reported judgment.
Court petition 2021, volume 1, case is here, page 41.
Yes.
The lordship would also notice, this was a demand in the year 1957, and sale not in the year 1969. Within 15 years, it has been sold.
Yes.
And the final conclusion that even under those conditions, the proceedings have been initiated belatedly. The proceedings before the assistant commissioner and the deputy commissioner would not be maintained. Based on that, both the orders of the assistant commissioner and deputy commissioner have been set aside.
Yes.
This over has not the other point that I'm trying to cancel before this one was for. That if a land is granted for a set price, then the provisions of those conditions that have been imposed at the time of grant, whether it would be applicable or not in case there is for an set price. In that way, not based on the effect of
Yes.
before we get ILR 2000. 4761. Not where it was there, that the property land was granted for an upset price.
Yes.
Court not the reform report would come to conclusion.
Yes.
That in a case not where the property value is already taken, then it would not be a free land. Therefore, when it is not a free land, not these conditions not be applicable. That is the writing that has been accepted and provided by this one.
How do you ascertain the market value?
But,
What material have you produced?
upset price has been paid on 20th.
How much was paid? Under the Mysore Land Grant Code, upset price is defined. It is subject to the facts of each case.
Equal to the market rate.
Market value. So what material has been produced to show that was the upset price and the act is not applicable?
So in so far as even before the law,
Yes.
not have taken that particular condition. But however, it appears not be exhibited often. That there is no document not to indicate what exactly was the market value of the property as of the date of
So it was your contention that it does not fall within the mischief of the act.
Therefore, on these 2 points,
So that may not stand then. Upset price may not stand in the absence of material. Yes, what do you say? So you concede. You have no case. All right. But present petition by the petitioner seeking following relief. Case of the petitioner is that land bearing serve number, old serve number 71, new serve number 114, measuring Kutkoli, please, 2 acres, situated at Chaudenahalli village, Lakkur Hobli, Maluk Taluk, was granted against the payment of upset price in favor of
the grandfather of the respondent 4A.
ಹೆಸರು ಅವ್ರದ್ದು ಗುರ್ರಪ್ಪ one Gurrappa son of Papaya on 30/11/1963 under Darkhast. There was a condition of non-alienation of the said land for a period of 15 years. However, by a deed of sale dated 12/1/1968, they said Gurrappa ne sale madida. That Gurrappa had conveyed the aforesaid property in favor of the husband of the petitioner, namely Sri Venkataswamy. Full stop. That the respondents four to seven had initiated the proceedings before the third respondent alleging violation of the provisions of section 4 and 5 of the PTCL Act and seeking restoration of the subject land in the proceeding bearing number so and so 4/2015-60. What are the proceedings? SC LND SC ST 14 of 2006 and 2007. The Assistant Commissioner Kolar, by its order dated 29/7/2015, allowed the said petition of the respondents and directed restoration of the land. Being agreed with the same, the petitioners herein filed appeal before the second respondent in RA SCST number 4 of 2015-16. The said appeal also came to be dismissed by order dated 24/1/2018. Being agreed with the same, the petitioner is before this court. That accounts for the petitioner, Sri Shankar Reddy, reiterating the grounds urged in the memorandum of petition, submits that there is submits that the first and second and third respondent have failed to appreciate that the grant was against the payment of offset price, which was equivalent to the market value. Therefore, the same would not fall within the provisions of PTCL Act. He also submits that alternatively, even if it is to be held, the land grant would fall within the provisions of PTCL Act in view of the inordinate delay in seeking restoration of land and in view of the law laid down with the apex code in the case of Nikkanti Adhapolity. The second and third respondent were in error in allowing the petition. The council also relies upon the judgment of this court in the case of Kumbaya and others versus Deputy Commissioner, Tumakuru District and others, 2021 KCCR 641, and A. Narsimurthy versus State of Karnataka, ILR 2000 KS 4761, in support of his contentions, and seeks for the allowing of the petition. On the other hand, Shri B.M. Manjunath and accounts for the response. Tamesra Manjunath? Tamesreli. Amar. Shri Amar, the council appearing for the respondent, submits that there was a delay in initiating the proceedings before the second respondent. However, he also submits that since the petitioners have not produced any material before the respondent number 2 and 3 to show that the land was granted against the upset price, it cannot be said that the provisions of PTCL Act would not apply. Heard and comes to the petitioners and the petitioner and the respondent, there is the records. Though it is contended by the petitioners that the provisions of PTCL Act would not apply, inasmuch as the land in question was granted against upset price, it is fairly submitted by the response to the petitioner that no material has been produced with regard to the amount of upset price paid. However, the council submits that in view of the law laid down with the apex code in the case of Nikkanti Rama Lakshmi Supra, admittedly, there is an inordinate delay in respondents initiating the proceedings before respondent grantees, initiating the proceedings before the respondent number 3. In that, The grant was made on 30/11/1963. Upset price was paid on 20/1/1964. The first deed of sale was executed on 12/1/1968. Vesting the title in favor of the husband of the petitioner. The respondents / grantees made application before the Assistant Commissioner, respondent number 3, only in the year 2006-2007. Almost close to 40 years. How the? 30 years. Almost 38 years. Almost after expiry of 38 years. In view of the law laid in the apex court, in the case of Mukhanti Ramalakshmi aforesaid, the amount of inordinate delay in the present petition would not give any cause for consideration in favor of the respondent grantees. In depth of the matter, petition deserved to be allowed. Order passed with the second and third respondent set aside. Yes. Caste rate amend ಮಾಡಬೇಕಾಗಿತ್ತು. You have to amend the caste rate. ಮಾಡಿ, you have to also file the amended caste rate. ನೋಡಿ ಹಾಕಿ ಇವತ್ತು ಕೋರ್ಸ್ ಅದ ಹಾಕಿದೀರಾ? ಮಾಡಿ ಇವಾಗಲೇ ಮಾಡಿ. And counsel for the petition submits that the amended caste rate has been already filed. Office to verify. Petition counsel to permit it to amend the caste rate. ಮಾಡ್ಬಿಡಿ ಇವಾಗ. ಆಗಿದೆಯಾ? ಆಗಿದೆ. ಮತ್ತೆ ಯಾಕೆ ಬೈತಿದ್ದಾರೆ ಹಾಗೆ? All right, next.
Number 40. To Nagendra Kumar.
Why the date was fixed in this matter? ಏನಿದು? What's the matter? There are so many repetitions are pending and some more additional documents. So many repetitions, several repetitions, rest is there. The request of the counsel for the petitioner, enabling him to furnish the details of the pending writ petitions. Iday matter connect agiroda? Arising out of the issue involved in this matter. Yes, list this matter on.
Yes, now.
10th.
Number 41. Department.
Forty-one. Annexure N. Yes. Yes, para 9.
There are two issues. One is ownership. Second, not
What does it matter?
According to us, not they have constructing house the site property belongs to municipality. That was the reason. Earlier, a complaint was not for the local sent a report and it's connected.
Yes,
It's the paragraph 2.
yes. Huh.
ದೂರುದಾರರು ತಮ್ಮ ದೂರಿನಲ್ಲಿ ಪಟ್ಟಣದಲ್ಲಿ ಒಂದು ಮೇಲೆ ಕಟ್ಟಡ ಪರವಾನಗಿ ಪಡೆದ ಹಲವಾರು ದೂರುಗಳನ್ನು ಅಕ್ರಮವಾಗಿ ನಿರ್ಮಾಣ ಮಾಡಿತ್ತು ಅದನ್ನು ಬರೆಯುವಲ್ಲಿ ಮಾಡುತ್ತಾರೆ. ಇದರಿಂದ ಸರ್ಕಾರ
Yes.
ಆದ್ದರಿಂದ ಆದ್ದರಿಂದ ಕರ್ನಾಟಕದಲ್ಲಿ
ಪಾರ್ಕಲ್ ಮನೆ ಕಟ್ತಾ ಇದ್ವಿ.
Municipal can decide the property ownership is question between municipality and private person. The need to chase the ethical is to hold a fire. Yes, part of the regarding ownership. One property is not the property is not the municipality according to us. Therefore, not you take assistance steps not according to not exercise something, you know, for filing. Otherwise,
No, when the ownership is involved between you and them,
yes.
how can DC sit on it? DC himself is ex officio member alva. How can he decide? 82 of municipalities. Yes.
Survey of land, certain land, has been of whether any property or any right in our over any property, right, by or on behalf of or by or any person. It shall be lawful for after inquiry, after notice given to pass to not deciding.
Next.
Any smooth after expiration of 1 year in the date of any order passed and the subsequent or one or more appeals are made in the order then the date of any order passed although this has not been taken from the suit is not set aside such order or is the relief claim is that is regarding subsequent. Therefore, deputy commissioner is authorized or empowered to decide any claim with regard to private or municipality, not any charge. One of the case, not here, they are consulting a building, the property belongs to municipality. Therefore, these positions has to be taken in accordance with law. That's why I felt no. No, the notice issue kind of into notice.
No. Read section 81 once again. 82 1 what you said?
Any municipal area to be survey land understand that has not validly extended under or whether any property or any right in or over any property is claimed by or on behalf of the state or by any person as in this it shall be lawful for the commissioner after inquiry of it due notice has been given to.
Now you have issued the notice of inquiry. You have issued or you have to notice ಕೊಟ್ಟಿದ್ದೀರೇನು? Have you issued a notice now?
No, we are
You are not issued notice.
ourselves pass order.
Oh, you have taken upon yourself.
Yes.
One submission I made. I understand my lawyer coming in my aid. But the way he submitted and indicated 82 will not occupy, will not get any significance. Reason is, my lord, all the properties we have been holders, we have purchased under a safety. Irony of the situation is that, my lord, I applied for the license for the construction in one matter, my lord, hospitals in another matter, some complaints. Then, my lord, online applications for license were taken up. I have produced the endorsements. Then, my lord, all of a sudden, they said that, my lord, nothing was proceeded further by the municipality. They kept quiet. They gave no objection for me to obtain JEB license and for the power connection, everything they did, even to the pollution control board, because I am maintaining a nursing home. Then, my lord, on the complaint of the third person to the honorable locality, a notice has been issued, which may not be challenged before the honorable division bench. Honorable division bench, my lord, has held that the opinion and report of the honorable locality is not going to create of the municipality. Because we were not in quite hurry.
Correct.
party. If here we have made construction without obtaining license, what is to be done? That is the scope of inquiry. There was no melon on the earlier occasion. Or in the objections hearing that we are not the owners of the property. The scope cannot be employed like that. In the memo, what may the
And there is no determination either.
Why not?
There is no determination either thus far.
No, ownership may not.
So we cannot prevent them from raising the issue as and when they want.
These issues may not at this point of time, past by 120, do not come to this gate because in the earlier objections, in the earlier restriction, even in the restriction or to the effect that we have not obtained license. That's all. Now, in the memo, they say that in the notice kind of issue, the improved notice which may not be not considered and granted improved, they are also under also election fee.
Yes.
The first matter,
They only say you are not obtained and so their property.
that's all. They function after immediate based on the same argument.
Correct. Let them be inquiry. Let them take action. If they want to protect the property, let them protect it in accordance with law. You prove your case, Aste.
My lord, in the memo, that is not right.
Can we stop them? Is there estoppel?
What is not there?
Is there an estoppel? No, annexure P last paragraph. ಓದಿಯದು ತಗೊಳ್ತೀವಿ ಅಂತಾರ ಅಷ್ಟೇ ಅವ್ರು. ಇನ್ನೇ ಇನಿಷಿಯೇಟ್ ಅಂತಾರ ಆಯ್ತು ಓದು ತಾವು ಅವ್ರು ಹೇಳ್ಬಿಡ್ಲಿ ನಾಗರಾಜ್ ಅವ್ರು ಹೇಳ್ಬಿಡ್ಲಿ ಅವ್ರು ತಮ್ದು ಗೊತ್ತಾಯ್ತು ತಮ್ಮ ಸಬ್ಮಿಷನ್ ಗ್ರಹಿಸಿ ಆಯ್ತು ಅವ್ರದ್ದು ಕೇಳ್ಬಿಡೋಣ ಏನಂತ ವೈ ದಿಸ್ ಪೆಟಿಷನ್ should be allowed ಅಂತ ಕೇಳೋಣ ಅವ್ರಿಗೆ. Yes.
As per the memo, the notice may kindly be filed. And the contentions may not be kindly kept open.
We'll keep open everything. Give them opportunity to take action. So now you are claiming the property is the public park.
Yes.
ಅರ್ಥ ಆಯ್ತು. We will not get into all that. We'll keep everything open. ಯಾವುದು?
Page 75.
ಓದಿ.
Paragraph 7.
Yes.
6th line.
Yes.
In that regard, from the court where issued the notice to the petitioner, will take note of the mistake that would be given by the petitioner and also documents that would be relied on and take independent decision in the matter relating to ownership by the mark, as well as manner in which the concern.
Everything.
This statement where if they would have followed, I would have not made before you.
Why did not do this? These petition, all the same question, all three petitions.
187 but the result aspect. No, will not be, if they won't give any answer with regard to the construction or handling or rejecting. If the consent will be there. Of course, since we very independently have been done by them, so on these aspects. On the continuation.
Money. These petition by the petitioners a file being agreed by issuance of a notice dated 18/9/2019 at annexure P. In and by which? Annexure P. In and by which? Yes. Adu nodi haki annexure nodi more petition. In and by which? Referring to the report of the Karnataka Lokayukta dated 10/5/2017 and the order passed by this court in the petition number refer madla idralli petition madidira petition ide petition with reference to the order of the writ petition numbers, order passed by this court in writ petition number 690-690/2018 the respondent authorities have called upon the petitioners to vacate the premises bearing number so and so ಅದೆಲ್ಲ each and within 15 days. And have further stated that in the event of failure on the behalf on the part of the petitioner, proceedings under the provisions of Karnataka Public Premises Eviction of Unauthorized Occupants Act 1974 and under section 187 of the Karnataka Municipalities Act 1964 would be initiated. It is the case of the petitioner that they are the absolute owners and also for an actual possession enjoyment of the property bearing number 2222 bar 2121 bracket new Khata number 2740 bar 3990 bar 2222 situated at Tumkur Road, that the petitioners have obtained electricity supply connection from Bescom and have also obtained NOC from TMC Madhugiri, the third respondent, and they have been paying the property tax regularly to the third respondent. That they filed application, online application, seeking approval of building plan in respect to scheduled property. And were also successful in submitting the online application. That on 30/11/2017, petitioner received the impugned notice. It's a notice dated 23/11/2017, where the third respondent. From the third respondent, wherein the petitioners were called upon to remove the construction put up by them on the scheduled property, claiming the same to be the illegal construction. In the said notice, there was a reference made to the report of the Lokayukta under section 12 bracket 1 of the Karnataka Lokayukta Act 1984. The Honorable the Upalokayukta in his report dated 10/5/2017 had made certain recommendation. It is contended that the said recommendations were made without hearing the petitioners, as they were neither notified nor made parties in said report. That pursuant to that report, third respondent had issued notice dated 23/11/2017. Agreed with the same, the petitioners had filed writ petition number 690-693 of 2019 before the division bench of this court. This court, by its order dated, division bench of this court, by its order dated 18/7/2018, disposed of the said writ petition. Paragraph 7 and 9 of the said writ petition, said order are extracted hereunder. The respondents, without complying with the directions given by the division bench of this court as extracted herein above, it again issued notice at annexure P, terming the petitioners to be unauthorized occupants with the threat of disposition, constraining the petitioner to approach this court. Sri Nagaraj, and counsel for the respondent, submits that erection fee is merely a notice, and the rights and obligation of the parties yet to be determined. Mere issuance of notice would not give cause of action, oblique right, in favor of the petitioners to file the present petition. He further submits that he fairly submits that though it is termed as a notice, the tenor of the notice amounts to an order terming the petition to another of the occupants. He refers to section 82 of the Karnataka Municipalities Act 1964, which vests power with the commissioner, deputy commissioner, to conduct an inquiry in the event of claim and counterclaim in respect of the property. He submits that such an inquiry contemplated in the Act would be conducted. In that view of the matter, we'll observe it.
Ownership matter is not touched. That will para 7, that is the tenor of the orders of the honorable intervention. Now, if we enquiry scope is not there are any somewhere that is my interest may not, because that is to be protected by law. And if it is not in para 7, the honorable division bench, that's why my hand anxiously executed. Then you are not idea, it's not necessary.
And here in that regard in the para 7.
Otherwise, to that extent, I will refer to the fiction papers and that we have opinion that report dated 10/5/70 shall not be taken by respondent number 4 as conclusion. It will be with regard to the status of the property relating to the ownership as well as construction.
Yes, next one.
Next one. In that regard, the award issue notice that take note of the display that would be given as also the documents that would be relied on and taken independent decision. Ownership.
Yes. Anyway.
So, that's why 84 if that is specific to service micro areas. The matter then asked these
No. These, that's why you say we'll keep all those questions open.
Yes.
We will not give any conclusion.
Yes.
Right.
My anxious official is
Yes.
common problem or
Yes. In response, the Balagangadhar, that counsel for the petition submits that the issue regarding ownership would go to the root of the matter, and same cannot be left to the discretion of the respondents to determine. Referring to paragraph 7 of the order of the division bench extracted here and above, he submits that the claim of the respondent regarding the property cannot be taken as a conclusive one without affording opportunity to the petitioners to put forth their case regarding the ownership. Submission taken on record. As already noted above, the present petition is a second round of litigation. In view of non-compliance of the direction issued by the division bench of this court, as referred to above by the respondent number 3. Had respondent number 3 meticulously followed the direction issued in paragraph 7 and 9 of the order extracted here and above, even 8 could have been 7, 8, 9. There was no occasion for the petitioners to have approached this court without adverting to the merits or demerits of the claim being put forth with the petition the respondent with regard to the ownership or with regard to the construction. This court is of considered view. The parties be relegated to the authorities under the Act to CMC, third respondent. CMC varadilla. CMC kotra puna adagati ಮಾಡ್ತಾರೆ ಅವರು. ಪುನಃ ನಿಮಗೆ ಕಳಿಸ್ತಾರೆ ಇಲ್ಲಿ. ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್. be relegated to Deputy Commissioner, who shall, after affording sufficient opportunity to the petitioners, as well as number 3, pass appropriate order in accordance with law, keeping in mind the direction issued by this court at paragraph 7, 8, and 9 of the order extracted here and above. All contentions that are available under law to the parties to be raised before the Deputy Commissioners is kept open, including the jurisdiction to determine the issue of ownership. All right. ಬರೋದಿಲ್ಲ ಅದು ಮೋಸ್ಟ್ಲಿ ಬಂದಿರ್ಲಿಕ್ಕಿಲ್ಲ. That might not have been brought to ಅದು to the authorities ಹಾಕಿದೆ. ಅಲ್ಲಿ ಆಗೋದಿಲ್ಲ. You see, there are two things. Even if you consider that you are an unauthorized occupant for the sake of it, they have no right to evict you without having recourse to Public Premises Act. They do not have right. When the question of ownership is concerned, at they do not have jurisdiction. They are the adversarial parties to you. Both of adversarial parties, so they cannot take up the cause upon themselves. No, keeping in view of the section 80 to refer matter. Yeah, no, go ahead. No, what's the way out then? It will go back to them only then. Correct. No, that's fine. No. With regard to the ownership is what we said. See, what may lie at their doorstep is only with regard to the authorization construction. With regard to the ownership is concerned, it may not go to them. It has to go to section 82. No, correct. That's why we said. Please. We will say that. Sorry, it is clarified that though in the order passed by the division bench of this court, directing respondent number 4, who is respondent number 3 in the present proceedings, to pass appropriate order, that would be to the extent of validity or otherwise a sanction plan. As regard the ownership is concerned, it has to be in accordance with the law provision for Karnataka Municipal Corporation Act. Yes. All contentions left over. Yes, the respondent, such proceedings shall be concluded with an outer limit of 6 months from the date of receiving certified copies of this order. In the meanwhile, respondent shall not take any precipitative action against the petitioners till disposal of the proceedings before the. Yes. No. Right. As long as it advances the cause. Yes, dispose.
I'm for the respondent number 7, my lords, in this case.
It has to go, Allah. Annexure P has to. Annexure P and G, na?
P in one matter, P in another. P in two matters.
Annexure P in 2 matters, D in 1 matter. Are quashed. What date? Mohan? It must be one. Selection yes.
My lords, I'm for the respondent number 7. My lords, I may be granted 2 weeks' time, my lords. I'll file the objections to the petition.
You are respondent 7.
Indeed, my lord.
One niche. Hey, what's the matter?
The two sites was granted.
What is the petition?
The two sites are granted by the government. One is for respondent number 6, another one is respondent number 7. The respondent number 6 said, obtain the permission from the concerned authority. The board the site in favor of the petitioner.
Respondent number 7.
6.
Site number,
Site number 8.
80. ಯಾರು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 7 ಗೆ ಲಾಟ್ ಆಗಿದ್ದ?
6 ಲಾಟ್ ಆಗಿದೆ. They have sold the site in favor of the petitioner.
ಯಾವಾಗ ಲಾಟ್ ಆಯ್ತು?
Lat is 77.
Date.
24/2/77.
24/2/1977. ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ. ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ಅವಾಗ. ಸೇಲ್ ಡೀಡ್
30.
ಡೇಟ್ ಸರ್
21/1. Another site getting number 82 was allotted in favor of the respondent number 7. The respondent number 7 had a sale agreement in favor of the respondent number 6. On the basis of the agreement, the respondent 6 had changed the Khata from the concerned department. The only thing is that thereafter the respondent number 6 had filed a suit against the respondent number 7. Suit has been dismissed and they have filed an appeal. Appeal has been dismissed. In the appeal, they directly concerned the revenue authority taken back the site number 80 meters. The wrong side. The one thing is client petition name is Vasal and respondent number 7 is also 94. There is no connection with the.
Where is the order? Where is the order?
Number 73. So there is no dispute with regard to my property and.
In page number?
And 91.
RA is dismissed. ಎಲ್ಲಿದೆ? ಯಾರು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
ಶ್ರೀಮತಿ ವಸಂತ ಕೋ ರಾಮಚಂದ್ರ ಖಾತಾ ನಂಬರ್ 1440/80 ಗ್ರಾಮ ಪಂಚಾಯತಿ ವಸತಿ ಪಡೆಯುವ
ಓದಿ ಅದು ಪೂರ್ತಿ ಓದಿ ಅದು.
ಬೆಳಕೋಡೆ ಗ್ರಾಮದ ಶ್ರೀಮತಿ ವಸಂತ ಕೋ ಬೆಳಕೋಡೆ ಗ್ರಾಮದ ಸಣ್ಣ ಶೆಟ್ಟಿ ಜಿಂದೇಟ್ ಮಾಲಶೆಟ್ಟಿ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ ನಡವಳಿಕೆಯಲ್ಲಿ ದಾವಾ ಸಂಖ್ಯೆ 26/14 ಖಾತೆಗೆ ಸದಸ್ಯತ್ವವಾಗಿದೆ ಎಂದು ಖಾತೆಯ ಜನರನ್ನು ಹೊರಡಿಸಬೇಕೆಂದು ಮತ್ತು ಪ್ರಕರಣದ 26 14/40/80 80 ಸೈಟನ್ನು ನೀವು ಯಾರಿಗೂ ಯಾವುದೇ ಇದರಿಂದ ಯಾವ ಕಾರಣಕ್ಕೂ ಪರವಾನಗಿ ಮಾಡಬಹುದು. ಈ ನಗಾಟು ಒಂದು ವರ್ಷಗಳಿಗೆ ಕಾನೂನು ಮಾಡಿದಂತೆ ಮನೆ ನಿಮಗೆ ಕೊಟ್ಟಿರುವ ಯಾವ ಪರಿಹಾರ ವಾಪಸ್ ಎಂದು ತಿಳಿಸಿದ್ದೇನೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸಂಪೂರ್ಣ ವರದಿ ಸರಣಿ ಪ್ರಕರಣ 26 ಅರ್ಜಿಗಳ ಸಂಖ್ಯೆ 14/40/80 ಸದರಿ ಮನೆಗೆ ವಾತಾವರಣದಿಂದ ನ್ಯಾಯ
How is this applicable?
Getting from the point number 6, I sold the property to the petition.
Correct. Who is appealing for the authority?
Mr. Somayaji is appealing.
Yes, Mr. Somayaji. With Vijay Somayaji.
Seal number 45, my lord.
Yes.
42, sir. 42, sir.
42 ಯಾವ ಕೇಸ್ ಗೊತ್ತಾಗಲಿಲ್ಲ.
42.
Mandya, sir, please.
Seal number 42.
42 ನಂದು ಇಲ್ವಲ್ಲ.
ಉಂಟು ನೋಡಿ, ಕಾಸ್ಟ್ ಇಟ್ ನೋಡಿ, ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ನೋಡಿ. You have for respondent number 3 to 5.
ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಏನೇನೋ ಹೆಸರು ಹಾಕಿದ್ದಾರೆ, ನನ್ನ ಹೆಸರು ಮಿಸ್ಟೇಕ್ ಆಗಿ ನೋಟ್ ಮಾಡಿಲ್ಲ. ಅದು ಐ ಥಿಂಕ್ ಒಂದು ಲಾಸ್ಟ್ ಲೊಕೇಶನ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ನನ್ನ ಹೆಸರು ಸರಿ ಮಾಡಿದ್ದಾರೆ. ಬಿಜೆ ಸ್ವಾಮೀಜಿ ಮಾಡಿಲ್ಲ
ಬಂದಿದೆಯಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದಿದೆಯಲ್ಲ.
ಹೌದು, ನಾನ್ ನೋಟ್ ಮಾಡಿಲ್ಲ, ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತೇ ಆಗುದಿಲ್ವಲ್ಲ, ನಮ್ಮ ಹೆಸರು ಚೇಂಜ್
ಅದು ಆ ಅಸಿಸ್ಟೆಂಟ್ ನಮಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲಲ್ಲ, ತಾವು ನೋಟ್ ಮಾಡದಿದ್ರೆ.
ಅಲ್ಲಲ್ಲ, ಆರ್ಡರ್ ಶೀಟ್ ಬರ್ದಿರ್ಬೇಕು ನೋಡಿ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೆ ನಾನು.
Council, today's task list is reflecting your name for respondent number 3 to 5. BJ Somaya G, respondent 3 to 5.
ಇಲ್ಲ.
ತಾವು ಯಾವ ಕಾಸ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
ನಾನು ಹಾಕಿದ್ದೆ, ನನ್ನ ಹೆಸರು ಹಾಕಿ. ನಾನು ಇದ್ರಲ್ಲಿ 46 ಮಾತ್ರ ತೋರಿಸ್ತಾ ಇದೆ, ಮತ್ತೆ ಯಾವ ತೋರಿಸ್ತಾ ಇಲ್ಲ.
ನೋಡಿ, ನಮ್ಮ ಹತ್ರ ಇರೋ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತಮ್ಮ ಹೆಸರಿದೆ, ತಮ್ಮ ಸಹೋದ್ಯೋಗಿಗಳ ಕಾಸ್ ಲಿಸ್ಟ್ ತಮ್ಮ ಹೆಸರಿದೆ, ತಮ್ಮದೊಂದು ಬಿಟ್ಟುಬಿಟ್ರು ಬೇರೆ ಎಲ್ಲರ ಹೆಸರಲ್ಲಿ ತಮ್ಮ ಹೆಸರಿದೆ.
ಸ್ಪೆಲ್ಲಿಂಗ್ ಮಿಸ್ಟೇಕ್ ಆಗ್ಬೇಕಂತ ಗೊತ್ತು ನೋಡಿ.
ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ಲ? Yes, this is regarding the site. ಮಳವಳ್ಳಿದು ಬೆಳತ್ವಾಡಿ ಗ್ರಾಮ.
Yes.
ಆ ಸೈಟ್ ನಂಬರ್ 80 and 82.
ನೋ ಐ ರಿಮೆಂಬರ್. ಅದು ಎಸ್ ನಾನು ಫೈಲ್ ಇಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಪಾಸ್ವರ್ಡ್ ಬೇಡ. ಏನಾಗಿದೆ ಅಂದ್ರೆ, ಪಿಟಿಷನ್ ಇಸ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ ಇನ್ ದಿ ಸೂಟ್. ಅಲ್ಲಿ ಏನಾಗಿದೆ, ವಸಂತ ಹೆಸರು ಕನ್ಫ್ಯೂಷನ್ ಅಲ್ಲಿ ಸೈಟ್ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಇರಬೇಕು, ಅದು ಸೈಟ್ ನಂಬರ್ 80 ಇಸ್ ಅಡ್ಜಸೆಂಟ್ ಅಂತ ಹೇಳಿ ಇದೆ. ಅಲ್ಲಿ ಇದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದು ತಪ್ಪಾಗಿದೆ. ಕೋರ್ಟ್ ಆರ್ಡರ್
ಹೋಗ್ಬೇಕಲ್ಲ, ಅದು
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ರು.
ತಾವು ತಮ್ಮ ಅಧಿಕಾರಿಗಳು ಆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನ ತಗೊಂಡು ಇವ್ರು ಸೈಟ್ ಕೊಡಿ ಅಂತ ವಾಪಸ್ ಹೇಳ್ತಾ ಇದಾರೆ.
ಅದು ಯಾಕಂದ್ರೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಸೈಟ್ ನಂಬರ್ 80 ಅಂತ ಇದೆ.
ಕರೆಕ್ಟ್, ಸೈಟ್ ನಂಬರ್ 80 ಇರ್ಬೋದು.
ಅಲ್ಲಲ್ಲ, ಅದು ನಮ್ಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟದ್ದು 80. ದಟ್ ಇಸ್ ಅ ಮಿಸ್ಟೇಕ್ ಇನ್ ದಿ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಅಲ್ಲಿ
ಹಾಗೆ ಕಣ್ಮುಚ್ಕೊಂಡು ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ವಲ್ಲ. ಯು ಕ್ಯಾನಾಟ್ ಬ್ಲೈಂಡ್ಲಿ ಫಾಲೋ ದಟ್.
ಅದು ಕೋರ್ಟ್ ಮಾಡಿದೆ ಅಂತ ಮಾಡಿದ್ದು ತಪ್ಪಾಗಿದೆ. ಅದು ಮಾಡಬಾರ್ದಿತ್ತು, ಮಾಡಿದ್ದಾರೆ.
ಹೌದು,
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಸೈಟ್ ನಂಬರ್ 80ಕ್ಕೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ. ಸೈಟ್ ನಂಬರ್ 80ಕ್ಕೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ ಮಾಡಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್, ಯು ಮೇ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಆಕ್ಷನ್ ಅಕಾರ್ಡಿಂಗ್ಲಿ. ಸೆಟ್ ಅಸೈಡ್ ದಟ್ ನೋಟಿಸ್.
ಹೌದು, ನೋಟಿಸ್ ತಪ್ಪಾಗಿದೆ.
ಹೌದು, ನೋಟಿಸ್ ಹ್ಯಾಸ್ ಟು ಗೋ. But if you have any other thing, you can take action if they have also sold the property in violation of the conditions.
The mistake is committed by the court ಅಲ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿಕೊಂಡು ಹಾಗಾಯ್ತು, ಏನಿಲ್ಲ. ಅದು ಮಾಡಬಾರ್ದಿತ್ತು, ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನು
could have sold the property.
ಇದರಲ್ಲಿ this petition has to be allowed. There is a mistake on the part of the authority. ಅಲ್ಲಿ ಹೆಸರು ವ್ಯತ್ಯಾಸ ಬಂದು ದಿ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದಾರೆ.
Present petition by the petitioner seeking following relief. The above petition has been filed in view of the notice dated 25/11/2019 at annexure K issued by respondent. ಯಾರು ಇಶ್ಯೂ ಮಾಡಿರೋದು? ತಾಲೂಕ್ ಪಂಚಾಯತಿನ ಬೆಳಕವಾಡಿ. ಎಷ್ಟೇ ರೆಸ್ಪಾಂಡೆಂಟ್? 5. Respondent number 5, ತಾನೆ? It is the contention of the petitioner that was there any prohibition for alienation of property? ಎಲಿನೇಷನ್ ಮಾಡಬಾರ್ದು ಅಂತ ನಾನ್ ಎಲಿನೇಷನ್ ಇತ್ತ ಇದರಲ್ಲಿ? ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಮಾಡಿರೋದಾ? that the permission ಇದೆಯೇನು? All right. That on 24/2/1977, Town Municipal Council, Belakavadi, Malavalli Taluk, Mandya District, had issued Hakkupatra in respect of property bearing number 1440/80, measuring east to west 40 feet, north to 30 feet, in favor of respondent number 6, Respondent number 6, thereafter sold the said property in favor of the petitioner in terms of deed of sale dated 21/1/2013 after obtaining the permission from the concerned authorities on
Permission has been given on 19/4/2012, Annexure D.
19/4/2012 at Annexure D. That respondent number 7 was also allotted similar site bearing number 82 as per Annexure B. That the respondent number 7 had entered into an agreement to sell with respondent number 6 in respect of said site number 82 on 6/2/1983. That there was a suit filed by the respondent number 6 against respondent number 7 in OS number 195 of 2013, which came to be dismissed
On 25/4/2017.
on 25/4/2017, being agreed with the same. Respondent number 6 filed appeal in RA number
RA number 26/2017.
26/2017.
Disposed on 16/2.
The said appeal also was dismissed by judgment and order dated 16/2/2019. In the said order, the senior civil judge at Malavalli had made observation to take possession of the site allotted to respondent number 7. However, while mentioning the number of the site, instead of site number 82, site number 80 was mentioned. Pursuant to the said order, respondent number 5 issued impugn notice at Annexure K, directing the petitioner hearing to hand over the site within 3 days from the date of receipt of the notice. Being agreed to the same, the petitioner before this court. That accounts for the petitioner reiterating the grounds urged in the manner of petition submits that there are 2 errors committed by the respondent number 3, respondent number 5. In that, there is petitioner is neither the party in the suit in OS number 189, 195 of 2013 and RA number 26 of 2017, and the said proceedings were in respect of site number 82. Secondly, the name of the petitioner and the respondent number 7 are one and the same. Apparently, based on this mistake of identity with regard to the number of the site and the names of the petitioner and respondent 7, the respondent number 5, without application of mind, has mechanically issued the notice to the petitioner, who has lawfully purchased the property bearing site number 80 in terms of deed of sale dated 21/1/2013, that too after obtaining prior permission as per Annexure D. That being the fact, the council submits that the notice at Annexure K is unsustainable and same has to be quashed. Now, counsel, the respondent does not dispute the aforesaid aspect of the matter. Shri Somayaji, the counsel for the respondent number 5, fairly submits that the notice in question has been issued due to bona fide mistakes. He further submits that in the order, judgment and order passed in RA number so and so, there is a reference to site number 80, which ought to have been site number 82. And apparently, in view of the same said error, the respondent number 5 has been prompted to issue the notice, albeit to a wrong person, namely the petitioner hearing. He fairly therefore submits that the petition deserves to be allowed in view of this mistake, which has crept in due to inadvertence. Full stop. Heard, there is the records. It is not in dispute that site number 80 had been allotted to respond number 6 on 24/2/1977. It is also not in dispute that after obtaining necessary permission, respond number 6 conveyed the aforesaid site in favor of the plaintiff petitioner in terms of deed of sale dated 21/1/2013, thereby conveying the title and delivering the possession of the property to the petitioner in the manner known to law. There appears to be certain dispute with regard to site number 82 between the respondent number 6 and 7, which culminated in dismissal of regular appeal in RA number 26 of 2017. While disposing of the said appeal, the senior civil judge Malavalli has passed the at the operative portion has passed the following observation. Office is hereby directed to forward certified copy of the judgment to the Deputy Commissioner, Mandya, and the Chief Executive Officer, Zilla Panchayat, Mandya, for information and necessary action in accordance with law for the reasons at paragraph 15 to 20 of the judgment within 3 months under the intimation to this court. At paragraph 15 to 20, while adjudicating with regard to validity otherwise of the agreement which was entered into between the respondent 6 and 7, the senior civil judge Malavalli, instead of referring to site number 82, has referred site number 80, which belongs to the petitioner as noted above. Apparently, this has led to the confusion in the minds of the respondent number 5, who have, in the zeal of implementing the direction issued in the said RA number 26 of 2017, have issued the present notice to the petitioner. In view of the aforesaid facts and circumstances, and in view of the fair submission made by counsel for the respondent number 5, that the direction contained in the aforesaid RA number so and so pertains to site number 82 and not to site number 80 belonging to the petitioner, the present petition deserves to be allowed. Consequently, the following order: notice at annexure K is set aside, petition is allowed.
ಇದು ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಅಲ್ಲಿ ಸೋಮಯಾಜಿ ಬದಲು ಸೋಮ ಜಾಯಿ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದೇ ಸೋಮ ಜಾಯಿ ಅದು ಸ್ವಲ್ಪ ಒಂದು ವರ್ಡ್ ಹಾಕಿದೆ, ಅದು ಗೊತ್ತಾಗಲ್ಲ.
ಆಯ್ತು.
Number 43.
That will work. Yaru, who has moved the matter or to move matter? You had moved. Aura, ಏನ್ ಕೇಳ್ತೀರಾ?
Presentation not analysis that there is a construction which is adjacent taking place in the property in petitioner, and there is an encroachment. But not with the single trade not that either to which not the sort of temporary injunction which was rejected. We confirmed in a miscellaneous appeal also.
Food for what?
Food for injunction. What would be kindly statement of objection.
You are the private respondent.
And the private respondent. The two suits are pending between the same parties before the fact.
Property came to you in partition.
After partition, we are in position and we wanted to construct, we have taken.
You are the elder brother. You are the elder brother. ಕಟ್ಕೊಡಿ ಗೋಡೆ ಅವರಿಗೆ, ಕಟ್ಕೊಡಿ ಗೋಡೆ ಅವರಿಗೆ. ನೀವು ಅವ್ರ ಗೋಡೆ ಕಡಿಸ್ಬಿಟ್ಟು ನೀವು ಕಟ್ಬಿಟ್ರೆ ನೋಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಆದ್ರೆ ನೋಡಿ ಮಾಡಿ. Settle this matter. 2 weeks. You must advise. Huh? Notice. Yes, perfect. So accept the notice, respond number 2. Yes. Date.
14 November.
Heli. Go all out and
44. The BR mission.
yes. ಏನಿದೆ what's
Move the signboard which is put up in front of the petition, that is the ground. In fact, it was a picture had been taken with the calculator, and there was a structure existing for signal. They wanted to remove it. Then
ತಮ್ಮ ಆಸ್ತಿ ಮೇಲೆ ಹಾಕಿದಾರಾ? ತಮ್ಮ ಆಸ್ತಿ ಮೇಲೆ ಹಾಕಿದಾರಾ?
football and all.
ತಮಗೇನ್ ತೊಂದರೆ ಆಗ್ತಾ ಉಂಟು ಅದರಲ್ಲಿ?
Annexure had to make an annexure had to have produced photograph to show that how the main road is visible in the photograph. That will not obstruct the field of the any of the public at large. And the signal pole also.
ಯಾವುದು D6 ಅದನ್ನ ತೆಗೀರಿ ಅಂತನಾ?
ಅದನ್ನ ತೆಗೀರಿ ಅಂತ ವಿಜಿಟ್ ಮಾಡ್ತಾರೆ main road.
ಎಲ್ಲಿ ಹಾಕ್ಬೇಕು ಮತ್ತೆ? ಎಲ್ಲಿ ಹಾಕ್ಬೇಕು ಜನರಿಗೆ ಗೊತ್ತಾಗೋದು ಹೇಗೆ? Reality of life should also be seen alva sir. You must also see the reality of life alva. ನಮ್ಮ ಜಾಗನೇ ಆ ತರ ಆ ಜಾಗದಲ್ಲಿದೆ. ನೀವೆಲ್ಲ ಬೋರ್ಡ್ ಹಾಕಿದ್ರೆ ನಿಮ್ಮನೆ ಬಂದು ಕೇಳ್ತಾರಲ್ಲ ಇದೇನ ದಾರಿ ಇಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕಾ ಅಂತ. ಬೋರ್ಡ್ ಇರ್ಲಿ ಬಿಡಿ, ದೇ ವಿಲ್ ನಾಟ್ ಕಮ್ ಇನ್ ಟು ಯುವರ್ ಶಾಪ್. ಇಲ್ಲಾಂದ್ರೆ ಬಂದವರಲ್ಲಿ ನಿಮ್ಮ ಅಂಗಡಿಗೆ ಬರ್ತಾರೆ, ಇಲ್ಲಿ ಇದನ್ನ ದಾರಿ ಇಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕಂತ ಕೇಳ್ತಾರಲ್ಲ. Yes, ಅಷ್ಟೇ. But present petition is filed by the petitioner for the following relief. It is the claim of the petitioner that he is the owner of the property bearing number 1/58, 9th Main Road, 30th Cross, 4th Block, Jayanagar. That it is the further case of petitioner that the respondents have put up flag post and unauthorized metal structure and have caused irreparable loss to the property. ಏನೇನು ಫ್ಲಾಗ್ ಪೋಸ್ಟ್ ಹಾಕಿದ್ರ ಅಲ್ಲಿ?
ಸಿಗ್ನಲ್
ಅಲ್ಲ, ಅವರು ಫ್ಲಾಗ್ ಪೋಸ್ಟ್ ಅಂತ ಹೇಳಿದೆ. ಫ್ಲಾಗ್ ಪೋಸ್ಟ್ ಇದೆ. ಫ್ಲಾಗ್ ಪೋಸ್ಟ್ ಅವ್ರು ಹಾಕಿ ಬರಲ್ವಲ್ಲ, ಅವ್ರು ಯಾಕೆ ಹಾಕ್ತಾರೆ ಫ್ಲಾಗ್ ಪೋಸ್ಟ್? ಕಾರ್ಪೊರೇಷನ್ ಫ್ಲಾಗ್ ಪೋಸ್ಟ್ ಹಾಕಿ ಬರೋದಿಲ್ಲ. ಅವ್ರಿಗೆ ಪಾರ್ಟಿ ಮಾಡಿ ತಾವು ಹಾಕಿರೋದು ಕಮಿಷನರ್ ಮೇಲೆ ಹಾಕಿದ್ದೀರಾ, ಕರೆಕ್ಟ್. ಅದಕ್ಕೆ ತಾವು ಬೇರೆ ಆಕ್ಷನ್ ತಗೋಬೇಕು. ಕಾರ್ಪೊರೇಷನ್ ಯಾಕೆ ಬರ್ತಾರೆ? ಅದು ಯಾರು ಫ್ಲಾಗ್ ಪೋಸ್ಟ್ ಹಾಕಿರೋದು? ಅಲ್ಲ, ಅವ್ರೇನೋ ಎಲ್ಲಿದೆ ಫ್ಲಾಗ್ ಪೋಸ್ಟ್? ಎಲ್ಲಿದೆ? E10 ಅದು ಫುಟ್ಪಾತ್ ಮೇಲೆ ಇದೆಯಲ್ಲ, ಅದೇನದು? ಅಲ್ಲ, ಬೋರ್ಡ್ ಪಕ್ಕದಲ್ಲಿ ಇದೆ ನೋಡಿ. ಬೋರ್ಡ್ ಆಫ್ ಕೋರ್ಸ್ ತೆಗಿಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಆ ಬೋರ್ಡ್ ಪಕ್ಕದಲ್ಲಿ ಒಂದು ಚಿಕ್ಕ ವಾಲ್ ಎಲ್ಲ ಕಟ್ಬಿಟ್ಟು ಫ್ಲಾಗ್ ಪೋಸ್ಟ್ ಆಯ್ತು. ದಟ್ ಯು ಆರ್ ದ ಮೇನ್, ಯು ಆರ್ ಟು ಮೇಂಟೈನ್. ನೀವು ಹಾಕಿರ್ಲಿಕ್ಕಿಲ್ಲ, ಬಟ್ ಯು ಆರ್ ಟು ಮೇಂಟೈನ್ ದ ಫುಟ್ಪಾತ್ ಅಲ್ವಾ? ಹೌ ಡಿಡ್ ಯು ಅಲೋ? ಸಿಗ್ನಲ್ಗೆ ಪೋಲ್ ಅದು ಬೇರೆ, ಸಿಗ್ನಲ್ ಪೋಲ್ ಬೇರೆ. ಅಲ್ಲಿ ನೋಡಿ, ಕನ್ನಡ ಫ್ಲಾಗ್ ಕಲರ್ ಇದೆ ನೋಡಿ. No, no, no. This is the footpath. You have to clear it. You clear it.
It's a footpath, my lord.
You clear it.
Even my lordship, this fall will not affect the free of the general public.
That is, no. How did you allow the footpath to come, that flag post to come on that?
I'll get in so far this.
We take your submission regarding the name plate. That's fine. Name board is fine. But there you see NHA D10. Although money katbittidare. ಅದು ತೆಗಿಬೇಕು. ಅದರ ಕೆಳಗಡೆ ಒಂದು ಅದರ ಕೆಳಗಡೆ
ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ can find out ಮಾಡೋದು regarding signal.
ಅಲ್ಲ signal of course ಅದು nobody can touch it. Signal also doesn't come to you. ತಾವು ಇದು ತೆಗಿಬೇಕಾಗುತ್ತೆ ನೋಡಿ.
I get information and then it seems that the pole outside.
Yes, ಅದು ನೋಡಿ ತೆಗಿಬೇಕು ತಾವು. The request of the council for the respondent BBMP list this matter on 7th. Please. Yes. 2/3. Correct. Yes. 57. The request of the council for the respondent number 224 list this matter on. Fifteenth, 20th. Later, 2/3. Come in.
Application is ready and filed by today. This matter minor ownership.
54.
55.
Sir. Continue.
Continue. Number 45, Simon K. Will come ready. Thereafter, he has applied before the second respondent, at his annexure E and F. In the 21. So, application for license to run operative works and to issue NOC for installation of electricity. On the application itself, he has the application written and stating that Sadari Kattadada ಮೇಲೆ ಮೊಕದ್ದಮೆ ನಡೆಯುತ್ತಿರುವ ಕಾರಣ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಬಂದ ನಂತರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು. In fact, there is no cases pending in respect of building.
Where is that endorsement?
E and F.
Yes, if there is no litigation, you issue.
And the representation given by the petitioner, the endorsement was saying that he has considered the building authorized without obtaining license and
Yes.
without obtaining license, he has considered the building and also he has enforced the public road. Therefore, the license cannot be granted. And they.
What action have you taken?
Yes, there is a matter, there was public interest litigation pending before the Honorable Court.
Pending, is it?
No, it was allowed, petition was allowed, and there was the pollution control board has issued a objection, saying that it is within the prohibited area, 500 meters from the river. So that cannot be granted.
Where is that?
That is under the pollution control.
There is a reference to the petition.
Where is that endorsement? If you are not capable of installing, how can you ask for it?
The state endorsement has not been issued to the petitioner.
Whom has it been issued to?
We have not sent.
Whether your intended place of business falls within the prohibited area?
No, not like that. Miller, kindly see the annexure page number. Page number 12, Miller. Annexure E. The pollution control board itself has given NOC. This is the report of the sanction by the pollution control board. In the last line, Sadari ಸ್ಥಳದ ಪೂರ್ವ ದಿಕ್ಕಿಗೆ ಸುಮಾರು 500ರಿಂದ 550 ಮೀಟರ್ ದೂರದಲ್ಲಿ ಬೇಕರಿ ಹೊಳೆ ಹರಿಯುತ್ತಿದೆ. So it means it is beyond the 500.
Where did you read that? Where did you read that? Which paragraph?
Last paragraph. The condition.
Condition number 9.
Condition number 4-5 minutes.
Annexure C, annexure ಯಾವ್ದು ಇರ್ತದೆ?
Annexure B, annexure B. Dated 18/10/2016. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಸದರಿ ಸ್ಥಳದ ಪೂರ್ವ ದಿಕ್ಕಿಗೆ ಸುಮಾರು 500ರಿಂದ 550 ಮೀಟರ್ ದೂರದಲ್ಲಿ ಬೇಕರಿ ಹೊಳೆ ಹರಿಯುತ್ತಿದೆ.
What does it say?
It is not coming within 500 meters. So this report, the NOC has been given by the board itself.
No, this is for the purpose of conversion. Last paragraph, Bodhi.
Conversion only.
You are saying no objection. Read last paragraph.
ಮಾರ್ಗಸೂಚಿ ಇಲ್ಲದ ಕಾರಣ ಹಾಗೂ ಉದ್ದಿಮೆಯ ಸುತ್ತಮುತ್ತ ಸುಮಾರು 500 ಮೀಟರ್ ಅಂತರದಲ್ಲಿ ನೆಲೆಸಿರುವ ಜನರಿಗೆ ಉದ್ದಿಮೆಗೆ ಸ್ಥಾಪನೆಗೆ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆ ಇಲ್ಲದ ಕಾರಣ ಉದ್ದಿಮೆ ಸ್ಥಾಪನೆಗೆ ಮುಂಚಿತವಾಗಿ ಮಂಡಳಿಯಿಂದ ಸ್ಥಾಪನಾ ಸಮ್ಮತಿ ಪತ್ರ ಪಡೆಯುವಂತೆ ಷರತ್ತು ವಿಧಿಸಿ ಸದರಿ ಸ್ಥಳವನ್ನು ಕೈಗಾರಿಕಾ ಉದ್ದೇಶವಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿದೆ.
ಇದು ಭೂ ಪರಿವರ್ತನೆ ಬಗ್ಗೆ ಇದು.
ಹೌದು ಸರ್. But regard to contentions of my learned friend.
No, you said Pollution Control Board has already issued the permission ಅಂದ್ರೆ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದೀವಿ.
Consent permission ಕೊಟ್ಟಿದೆ.
ಎಲ್ಲಿ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಅದಕ್ಕೆ ಕೇಳ್ತಾರೆ? ವಿಚ್ ಡಾಕ್ಯುಮೆಂಟ್? Annex D. ಅದು ಹೇಳಿ ಏನ್ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲಿ?
Dated 1/6/2020 it said.
Yes.
Combined consent for this has been given to start for a period of last line agreement.
ಯಾರು ಕೊಟ್ಟಿರೋದು ಇದು? Who has given this?
Board itself.
Which board?
Pollution Control Board.
Where do you find that?
Page number 18 and for and on behalf of Karnataka State Pollution Control Board. It is for a period of 15 years.
ಎಲ್ಲಿದೆ? Which paragraph?
Consent ಕೊಟ್ಟಿರೋದು. Page number 18 ಇದೆ. For and on behalf of Karnataka State Pollution Control Board. This consent has been withdrawn by the Pollution Control Board. Thereafter, a petition without giving the opportunity to the petitioner, the consent was withdrawn. The requisitions are 13/7/18 of 2021 has been filed under this honorable court. The honorable decision bench was pleased to allow the petition and directed the notice has been passed, issued by the Pollution Control Board and issued direction to reconsider. So hence there is no matter before any other course regard to this.
No, which means no consent with the Pollution Control Board as on this date. ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು ಅದು ಇಷ್ಟೆಲ್ಲ ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರೆ ಹೇಳಿದ ಹಾಗೆ. The court asks so many questions, then you come up and say. You started off saying the Pollution Control Board has already issued. There is no permission. Consider. No, your reason is something else. Your reason is there seems to be some litigation. Any appeal provided provision is there for against this? Under which provision? Under which provision? Who has issued this endorsement now? Against which? What is the remedy? What is the endorsement annexure? Where is the endorsement? 15. That's after filing of the writ petition. Have you heard him? Have you heard him before this? Mate? And the petition is pending. How could you pass this endorsement? Your representation answer is annexure F, wherein you have said that cannot be considered because the property is under litigation. That's a reason. Then after filing the petition, you issue this endorsement. How is this sustainable? Barkul. Consider this application. Present petition. To file seeking issue of writ of mandamus, direction to second respondent to grant license to the petitioner to run coffee curing works and also to issue no objection certificate for installing electricity, considering a requisition dated 3/6/2020 annexure E and F. Case of the petitioner is that he is the owner of land measuring 14.5 cents in survey number 113/3, situated at Nalkeri village, Virakpet Taluk, Kodagu district. That the second respondent has already issued no objection certificate to use the said land for commercial purposes by order dated 13/16/16. That the Karnataka State Pollution Control Board had also issued order dated 18/10/2016, according permission to use the land for the industrial purposes. That on earlier occasion, Karnataka State Pollution Control Board had issued a combined consent order dated 1/6/2020, valid for a period of 15 years from 30/4/2020 to 31/12/2034. Based on the aforesaid ownership and the documents referred to here and above, petitioner made an application before the second respondent seeking issue of NOC for installation of electricity connection to the erection, enabling the petitioner to install and run a coffee curing works. And also for issuance of license. When was that combined consent was withdrawn with the Pollution Control Board? Which is this writ petition, other writ petition 13/7/18?
9/10/2020.
After the writ petition.
No, before this.
No, this is 69, sir. This writ petition is September 2021. October comes after September.
September 2020.
Withdraw ಮಾಡ್ಕೊಂಡಿದ್ದ? Then you file this writ petition, you know. It is further case of the petitioner that the combined consent which was issued by the Karnataka State Pollution Control was unilaterally withdrawn, concerning the petitioner to approach this court in a writ petition bearing number 13789 of 2021. Division bench of this court by order dated 1/9/2022 has disposed of the said writ petition directing the Karnataka State Pollution Control Board to provide an opportunity to petitioner of hearing and consequently quash the said withdrawal of the permission. Full stop. In the meanwhile, the second respondent hearing had issued an announcement at annexure E and F, wherein upon the application filed by the petitioner itself, the respondent has written as under ಕೆಳಗಡೆ ಬರ್ಕೊಳ್ಳಿ. ಸದರಿ ಕಟ್ಟಡವು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿರುವ ಕಾರಣ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇತ್ಯರ್ಥವಾದ ನಂತರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು. ಕ್ಲೋಸಿಂಗ್ ಕಾಮ. Being agreed with the aforesaid endorsement made on the application filed by the petitioner at annexure E and F, the petition is before this court. Now, the counsel for the respondent submits that by memo dated 15/11/2021, endorsement dated 21/10/2021 issued by the second respondent Gram Panchayat is produced. He submits that which is this petition 85/28. What happened?
It was allowed, and the direction was issued to the police control board to cancel the consent given, because there was a guideline.
Refers to a public. Yes. Correct. The said endorsement, counsel for the respondent submit the said endorsement refers to a writ petition in WP number 8528 of 2020 filed in public interest, objecting for issuance of the license in favor of the petitioner. It further submitted that the said petition was disposed of, directing the Karnataka State Pollution Control Board to withdraw the consent earlier given.
To issue notice and inspect.
Where is the order? Kudi? Both of you are disputing.
He is relying on that.
So you are disputing that. Kudi order Kudi. We will not rely by either of you.
There is a two of the judgment.
Full stop. Thus, then comes to the respondent submits that in view of the endorsement 21/10/2021 having been issued, nothing survives for consideration in the petition. Full stop. In response to the efforts submission of the response to the respondent, the counsel of the petition submits that the petition in WP number 8528 of 2020 was disposed of by the division bench of this court, directing the Pollution Control Board to afford an opportunity before taking any action. As such, there has been no conclusion with regard to the entitlement of the petitioner to obtain license, public permission to run the coffee curing works. Thus, he submit the petitioner merits consideration. Heard and comes for the petitioner and respondent. Here is the records. It is seen that the combined license public permission, which was issued by the Karnataka Pollution Control Board in terms of Annexure D, has been withdrawn. Agreed by the same, the petitioner had filed a petition in WP number 13789 of 2021, which has been disposed of by the division bench of this court by its order dated 19/2022, directing the Karnataka State Pollution Control Board to afford an opportunity to the petitioner of hearing and then pass appropriate order, and consequently quashed the withdrawal of the permission granted earlier. Similar is the order in the public interest litigation in WP number 8528 of 2020, wherein the Pollution Control Board has been directed to afford an opportunity to petitioner before taking any action. As regards the action on the part of the respondent number 2 is concerned, though on the application that annexed E and F filed by the petitioner seeking issuance of license, it is endorsed that in view of the pendency of litigation before the court, it is only after the disposal of the pendency litigation of the court action will be taken. In other words, no decision was taken by the respondent panchayat and the application filed by the petitioner in Annexure E and F. However, along with the memo dated 15/11/2021, second respondent has issued yet another endorsement that is during the pendency of the present petition, to the effect that in view of the order passed in the petition number 8528 of 2028, there is no possibility of issuance of the no objection or the license. Full stop. In view of the aforesaid fact situation, more particularly the orders passed by this court in WP number 85828 of 2020 and 17230 of 2021, wherein this court has directed the Pollution Control Board to consider the case of the petitioner before taking any action, and also in view of the fact that the second respondent Gram Panchayat has not taken any decision on the application filed by the petitioner, except citing the orders passed by the by the division bench of this court in the affirmative petition, comma, this court is of considered view that second respondent be directed to consider the case of the petitioner in accordance with law, and if the petitioner satisfies or complies with the requirement of law, to proceed to issue license in accordance with law within a period of 8 weeks from the date of receipt of this.
Dispute on waiting. There is no dispute.
ಆಯ್ತು, ತಾವು ತಗೊಬನ್ನಿ pollution control board. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು, if he complies and if he satisfies the requirement of law, issue ಅಂತ. ಆಗ ಟೈಮ್ ಬೇಡ ಬಿಡಿ, will not fix the time. Sooner you get, better for you. Will not fix the time. ತಾವು ಕೊಡಿ ಕೊಡ್ತಾರ. ಆಯ್ತು, 10 weeks ಆಯ್ತು. ಅಲ್ಲಲ್ಲ, building dispute ಅಲ್ಲ, with regard to the you obtaining the permission from the clearance from pollution control board. ಆಮೇಲೆ 10 weeks ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರ ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬಿಡಿ ನೀವು. ಹಾ, ಅದು ಹಾಕೊಳ್ಳಿ ಮಾ. ತಾವು then it will be tool in your hand to harass them later. ಅದೇನ್ ಬರ್ತೀರ ಕೊನೆಗೆ? ಅಲ್ಲ, ಅದಕ್ಕೆ ಮೇಲೆ ಬರ್ಬೋದು. If the petition satisfied and complies, including furnishing of the required permission or consent from the pollution control board within a period of 10 weeks, 8 weeks from the date of receipt. Yes, adu kotre maadi. Yes, disposed. 10 weeks. Yes.
Serial number 46, my lord, I pray for 2 weeks time.
The request the cause for the respondent. ಏನಕ್ಕೆ why time, Mr. Somaji? There is a serious objection for you asking.
ಅದರಲ್ಲಿ ಇವ್ರು ಈಗಿನ ಪಿಡಿಯೋ ದೇ ಹ್ಯಾವ್ ಟು ವೆರಿಫೈ ಆಲ್. ಇದು ಮೊದಲಿನ ಪಿಡಿಯೋ ಟೈಮಲ್ಲಿ ನಂತರ ವಾಟರ್ ಸಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅವರು, ಅದಕ್ಕೆ ಕೊಟ್ಟದಕ್ಕೆ ವೆರಿಫೈ ಮಾಡೋಕ್ಕಾಗ್ತದೆ ಮತ್ತು ಮಗ ಡಿಸಿಷನ್ ಎಷ್ಟು ಟೇಕನ್ ಅದು.
Finally
2 weeks.
Finally 10 days time.
2 weeks ಮೇಲೆ 2 weeks time.
10 days ಅಂದ್ರೆ 2 weeks ಆಗ್ಬಿಡುತ್ತೆ, ಅದಕ್ಕೆ 10 days ಕೊಡ್ತಾರೆ.
2 weeks ಕೊಡಿ.
Finally, at the request of the council for the respondent number 3 and 4, finally 9th November. ಅವತ್ತು ಹೇಳ್ಬಿಡಿ.
2 weeks time ಅಲ್ಲ?
Yes, 9th November, 2 weeks ಆಗಿದೆ.
ಸರಿ, ವೆರಿ
7.
ಏನಿದು ಮ್ಯಾಟರ್? ಏನು, ಹೂ ಆರ್ ಯು? ಯು ಆರ್ ಎ ಪರ್ಚೇಸರ್. ಏನಾಯ್ತು? ವೆನ್ ಡಿಡ್ ಯು ಪರ್ಚೇಸ್? 1994. When was the grant? 1972. Who is the contesting respondent? ಯಾರು ಅಪೀರ್ ಆಗ್ತಾರೆ? ಯಾರು ಇದಾರ? ಲೋಕೇಶ್ ಮೂರ್ತಿ ಅಂತ ಹೇಳಿ.
ಲೋಕೇಶ್ ಮೂರ್ತಿ.
ಅದೇ 4148 to C ಅಂತ ಇದಾರಲ್ಲ ಯಾರು? ಸೊ ಹೇಳಿ, ಏನಾಯ್ತು ಆಮೇಲೆ? ಹಾ,
20 years.
Heard on the post for the petitioner. None appears for the respondent number 4A to C for the contesting respondent the matter. In the interest of justice, finally, to hear respondent number 4A to C, list this matter. 7th November, our heli. Finally, our error tabaki sikkadre heli avarige. Yes.
48. 48. Second respondent. Yes. Have this matter. Yes. The suspension of resolution part of the that resolution itself is not for 1 year. That 1 year is already elapsed.
Resolution.
Resolution is extending the lease period. Lease period of the complex, commercial complex. Therefore,
who are you? You are the president of Town Municipal Council. Town Municipal Council anta ide. Odi casted odi. In your individual capacity na Town Municipal Council official capacity.
I am representing
Ade sir, in the official capacity petition is filed against the assistant commissioner. What's the matter? Second respondent nodi. How is this petition maintainable?
Lease period itself is already over.
Factually.
Resolution passed, extending the lease period.
By whom resolution is passed, sir?
Chief officer sent to approval. Their problems are taken. And the assistant commissioner treating it as a section 306(1). The resolution passed by the government suspended and directed to vacate the premises.
Directed whom?
Directed to the tenants.
So who are you? Why are you taking the tenants' cause in this matter?
We have passed the resolution.
Correct. Let the tenants take action. Why are you taking on behalf of the tenants? You have shops there? Your people have shops there? Then? Fairly after. Council for the petitioner submit the petition because memo. File a memo. Could you paper could you? Yeah. In an infectious petition, what order? Petition, then comes with the petition submit that by passage of time, the resolution questioned in the writ petition has become infructuous. Petition does not survive for consideration. Petition dismissed as having become infructuous. Memo file
49. Resolution is not there. Therefore, the action has to be taken place.
You are the authority. You are the elected representatives. Who prevents you? Pass any resolution. Why you want court's permission for that? Why should the court intervene in your day-to-day administration, sir? That's your domain.
No. Why?
Don't.
Therefore, he is exposing cause of tenants. They themselves pass a resolution.
We have made this observation already. We don't want to make it further. You pass resolution whatever you want, sir. Who comes in your way? Yes.
49.
Same thing. ಅವರೇ ಇದಾರಾ? ಅವರೇ ಇದಾರೆ ಲೋಕೇಶ್ ಮೂರ್ತಿನೇ ಇದೆ ಇದ್ರಲ್ಲೂ. ಅದೇ ಇದೆ ನೋಡಿ ಲೋಕೇಶ್ ಮೂರ್ತಿನೇ ಇದೆ ಇದರಲ್ಲೂ ಕೂಡ R6 and 9 ಗೆ. ಅದೇನು ಒಂದೇ ಊರ ಇದು? ಇದು ಲಿಮಿಟೇಷನ್ ಸೇಮ್ ಆರ್ಡರ್ 47 ಮಾಡಿದೀವಲ್ಲ ಅದೇ ಆರ್ಡರ್. Yes, ಹೇಳಿ. What is this matter, ma? Khata transfer to be set aside. Why? Next week.
Respondent number 5 and 5 to 8.
Yes.
But the customer has to matter anytime after the fourth level.
Yes. What is the matter? You're opening the file now, next week. Very next. Which matter? 52. Next week. Yes.
This is a strange case. The commissioners purchased the property in the year 1994. Property is situated in the middle of Brigade. It's a commercial property on the second floor. By sale, they purchased the property in 94. Things are fine, the data is transferred, taxes are correct. In 1718, the Khata seems to have been changed in favor of respondent number 5. The petitioners are all the owners of the property are residing in Mumbai. They have let it out and subsequently they have not been able to come and pay the tax. In 2022, when they come to pay the tax, they find somebody else's name is entered. Then they file an application before they give a representation to the assistant revenue officer saying that they are not sold the property on one basis. Have you transferred the data in somebody? The assistant revenue officer refuses to receive even their representation. Then it is sent by registered. No reply is made. Then when the RTI, they apply for the documents how fifth respondent seems to have sold the property in favor of fourth respondent, according to the DPA. Khata is transferred in favor of fourth respondent. The incumbent certificate is produced, no sale transactions till the year 2020. Now, in the meanwhile, RTI, when it is applied to ask for the Khata transfer in favor of fourth respondent, as well as fourth respondent, they give only one set of documents and only in respect of the transfer in favor of fourth respondent and say those are the documents.
What?
And
How the sale deed has taken place?
the sale deed property is different. Schedule is a corner of brigade. And pages are missing in the copy that is furnished by the department. An FIR is registered in this. Now, from February, they wait because there is no response and petition is filed. No notice before the Khata is transferred and property is totally.
On what basis the Khata is affected? You are filing memo for retirement for respondent number 4 and 5. Have you issued a letter to them? Have they accepted? Totally.
Yes, possibly the court will not be there. Last time when it came up before this when I made noise on behalf of the petitioner, it was sought to be said they are going to file objection. And now we will have. I could say fraud has been played. There is a decision of the coordinate bench of this court. The last time the court said we could set aside the thing and set it back. But then they said no, it can't be set. Now I have asked for kindly see the prayers that was asked, but an FIR has been registered, the police are not taking any action. So we have sought for a direction to the police force.
Yes.
We have asked,
Who is for BBMP?
Lord, I am for
Yes, council. How has this taken place?
Lord, kindly see annexure R.
Annexure?
R. Lord, 214. This, my lord, is the taxpayer receipt standing in the name of your lordship.
214, yes.
214. Taxpayer receipt standing in the name of fourth respondent.
Yes.
This was, my lord, on 30/8/2019 itself. That is prior to the date on which the sale took place in favor of fifth respondent. So, my lord, as on the date, my lord, Khata was already standing in the name of fourth respondent, based on which, my lord, he has already paid these taxes also. Thereafterwards, fourth respondent sells it in favor of fifth respondent.
How did you change the Khata in the
My lord,
fourth respondent in the first place?
Lord, this is based on, my lord, the sale deed, whatever under which, my lord, the fourth respondent has taken.
Which sale deed?
Sale deed, my lord, they produced the sale deed. Based on that, my lord, I have taken the Khata. This was already standing in the name of fourth respondent.
Correct. Already
Kindly
meaning
see-
when? Already meaning when?
My lord,
When was the Khata effective?
Annexure Q,
Yes,
Annexure Q in page 199.
correct. The sale
My lord,
deed
this
is
is the
5
sale deed in favor of fifth respondent
by.
by fourth respondent.
How did fourth respondent get this
Fourth
property?
respondent, my lord, insofar as fourth respondent is concerned, my lord, I have sought for that Khata or the sale deed, my lord, which my lord, they are securing those documents. This is one aspect of the matter. Once that is received by me, my lord, I will produce that before your lordships. Secondly, my
No.
lord,
When did you get the Khata affected in the name of the
that
fourth
I have to
respondent?
take instructions. That is what I am saying. I have sought for that instruction. This is one. Secondly, my lord, may I request my lords to kindly see section, my lord, 149 for a minute of the BPMP Act. Or maybe it
This
is
was under
prior
the
to-
old, it was under the old act.
I was in the old act.
Yes.
And then 14A, may kindly see.
Review, fabrication.
Yes.
False. What action have you taken?
But they have not filed any review at all.
Why? When this material has come, you should take so
No,
much
they
action.
are supposed to come before me and then file necessary review of the application or whatever it is. Let a direction be given to him, I consider.
Fine.
Absolutely no problem.
Yes, but
Under 14. Alternative remedy is available to under the
Yes.
statute.
which is
Let him
the
come up and file it.
which is the provision now with the new act?
Under the new
that's
act,
one-
149(5)
149.5.
and 150 also.
Yes.
Let him file it. I will consider it.
Barcode.
Already mentioned this one before. The similar case, the fraud has been done. Has passed the judgment allowing the retribution, setting aside.
Lord, recently, my lord, Supreme Court has said, when there is an alternative.
No,
remedy-
fine. No. Alternate remedy is fine. We are not on that. Now you do one thing. We will not pass that anything. You get the details of when did you make the Khata into the fourth respondent? And what basis?
That I will secure it. No.
First they transfer it in favor of the fifth respondent.
No, he said.
No, that's wrong, because I have myself said in my petition. It was transferred in favor of the fifth respondent, they do not provide details as to how it was
No,
done.
he refers to page number 214, and he says the taxpayer receipt reflect the name of the fourth respondent.
No, fourth respondent.
It's just the trust which is the fifth respondent. And interestingly, online, we were able to get the SAS form. In that, he shows my client's name as the address in Mumbai. When we see this.
Yes.
I know I'm producing of the top, then this is all available online.
Yes, counsel.
Court sees, Kamlesh Thakur,
Mumbai.
No, I do understand that, my lord, fifth respondent, Khata was already standing in the name of fifth respondent is one much.
Correct.
I
No.
thought it was fourth respondent, but it is fifth respondent. Kindly see the sale date. Sale date is executed on 5/9/2019 by
No.
15 favor of fourth.
No, counsel. All that is fine. You see, the owner of the property is petitioner.
Please.
Respondent 4 and 5 seem to have come up now. Now you will have to answer on what basis did you affect the Khata in the name of fourth respondent?
That I will secure the instructions. That is one aspect, Lord. In the meantime, my lord, may make the submission. When there is a statutory
Not
remedy
necessary.
available to him,
If
kindly see, my lord.
the fraud is apparent on the face of the record,
Kindly see this.
why should we subject them to go to the
No,
process?
One second. Kindly see, my lord, 149(5) for a minute. 149(5) may kindly be seen and 150 may kindly be seen.
Yes.
as well as 114, which is parametric, same with this of,
Yes.
Note 149(5), where the chief commissioner, either suo moto or otherwise, after such inquiry as he considers necessary, he is satisfied that any transfer of title was recorded in the corporation register by fraud or suppression of facts or by furnishing false, incorrect, or incomplete material, may within a period of 3 years from the date of such recording of transfer of title, reopen the case. So, this is a statutory remedy available. When that is the situation, he can always approach the commissioner, and he does not even approach the commissioner, does not give the representation. He could have as well gone under 149(5) as well as 150 also. It is a statutory authority, statutory alternative remedy is available. Let him exhaust that and come before this court. He will be in a better position, to appreciate these facts. And the Supreme Court recently has passed this judgment also. When there is a statutory remedy available. Even fraud also gets covered under this.
Yes, let them dispose of it in 4 weeks. Correct. You see, the point is, in this case, there's a sale deed.
There is no, that sale deed is
Correct.
fake. They will not produce because of the sale deed as to how the correspondent became the owner.
Correct. So exhaust that within 4 weeks.
No, because kindly see my representation. It is not as if I'm going to state of the.
Where's the representation of yours?
Page 158. Annexure G, 8th February.
What's the answer for this?
They refuse to receive it.
This is the assistant revenue commissioner.
They refuse to receive it. It is sent by registered post later. 160, what was sent by registered.
But why have you not given it to the commissioner?
We are not given to the commissioner. Then kindly see the judgment of this one before department bench judgment. Where it says fraud has been paid.
No, fraud, of course, that vitiates. But there's a question of sale deed here.
Correct, but no notice has been issued. Principles of natural justice.
We'll give.
Even if I go, the has to be set aside, then it's be asked to go.
So, see, 114A corresponding to 149 now gives all that authority to the commissioner. Everything is included there.
I agree, but then when the person, no notice is given, they said they will.
Madly, that situation is contemplated.
The statement, what is the problem? What is the property in RTA when we apply? Kindly see the schedule.
Yes.
At page 212. 212.
Yes.
The calculation comes under the limits of founded on Brigade Road, MG Road. Kindly see our sale, it's right in the middle, it is second floor of a commercial property. I produced all the 5 safeties. Annexure ACVs are the safeties that are produced. Kindly see the first safety. Because undivided interest they have purchased. At page 37, 38. There is no MG road at all.
What are you referring? What are you referring to? What are you referring to?
I'm referring to my safety, my safety.
Huh?
This property is totally different. And even that SES form which I have produced, this is a measurement.
1 second. What's your property?
Our property is
Where's your property?
page number 39. The first day deed.
39.
Yes.
Yes.
I've given the description in page 11. Page 11 of the petition.
No, let's read page 39. Page 39, which is the property undivided share is mentioned there.
Description of entire property, schedule A.
Correct.
Herein before schedule B. So much undivided share title and interest in the renewable property known as road source situated in Brigade Road, in Corporation Division number 61.
Yes.
Office space in second floor without parking space in the multi-story commercial complex.
All right. Where is your Khata? Where is your
Khata we
Khata?
have produced
Where is your
at
Khata?
page 147.
Yes, read the Khata detail. This is property given there in your name.
At 147.
Yes, read the description.
That is constructions, certified that the Khata of municipal property bearing municipal number 53 Brigade Road, Bangalore, Ward number.
Yes, what is the Khata made now? What is the number given now?
Now, this ought to be given. They have
Yes.
only given me the copy of what is transferred in favor of the fourth respondent from the fifth respondent.
Correct. What is the number given there?
Yes.
'53 Brigade Road is entire property.
Of Karnataka property.
No, you said second floor portion you have purchased Antiliala.
Second floor, right in the middle of Brigade Road.
Correct. Where is the?
Beside it at page 11.
No, correct. So where is the Khata in respect of your property?
Yes, that will be sure.
No. You said the larger property is 53.
That is, no, it is not the largest property.
You see, schedule A of your sale deed.
Yes.
It has got 4 municipal corporation numbers. Come to page 133. Yes, it has got 4 municipal corporation numbers. 50, 51, 52, 53. Now the property purchase, undivided share of the property is in respect of all the 4 numbers.
It is all combined into one.
Correct. Let's understand.
Kindly turn to page 147.
No, Mr. Counsel, Senior Counsel, just a minute, just for the court's understanding. This is a composite property consisting of 4 municipal numbers.
Yes.
From 50 to 53, of which you have purchased a certain amount of undivided share of land, along with the built-up area.
But during the time when the sale deed was constructed, here, building never used to be constructed.
Correct.
In favor of companies, etc., the shares used to be transferred.
So now, how is this number 53 allotted to your share? Khata at page number 147 refers. Schedule C.
Office space in second floor without parking space in the multi-story commercial complex proposed to be constructed on the schedule A property.
Correct. There is no number to that.
There is number in schedule A.
Schedule A is, that's what we.
Schedule A is the entire
There's a-
compost.
Correct. No, please appreciate. The 4 municipal numbers to a land situated in the Brigade Road, which is 50, 51, 52, and 53.
Correct.
You seem to have purchased undivided share of a land with the right to have a built-up area put up thereon. Built-up area has not been defined with any number. Now, if you correspond your Khata at page number 147, it refers to number 53. How this number was allotted? This requires an inquiry.
Kindly see the. No, here, Garden City versus Brigade, all the names are mentioned.
Correct, sir.
Page 147.
That's why we are saying.
And kindly see page 148, Khata extract is there.
148, yes.
Khata extract.
Yes. Other
There,
53.
new number 53 is
Correct.
the corporation itself.
Other Lodi, kindly come to Khata extract 148. Come to column number 5, 6, 7, 8, 9. Everything is blank. No built up area, no cycle area. Nothing is there in that.
Kindly turn to page 149.
All right, 149. Tax paid receipt.
Yes.
PID number 761053. Let them look into it.
PID number.
To say your property is different, their property different, prima facie this.
The schedules.
Maybe.
No. I know only. The data has to be transferred to my name. There has to be a document. Till now, they have not produced any document. This writ petition is pending for the past now 5 months. They have been taking time on the premise that they are going to file their objection. Now, for the first time, they are trying to say all this. Now, if the court is not satisfied, we will produce documents to show that on the base of it is fraud. It is fraud on the face of it. Because how respondent number 5 gets till today, they are not giving the documents. And the RBI, we applied for separately for 4 and 5. They do not give any documents pertaining to transfer of property in favor of 5. And 5 himself is the name of the petitioners in his SAS form.
1 second. Council, read page number 212.
Please,
Read page number 212. See the scheduled property conveyed there. Read it.
Not a removable corner property, commercial property bearing number so municipal number 53, PID 761053. Situated on the eastern side of Brigade Road in cantonment of Bangalore, number 37, comes within the limits of so. Eastern side 91.8, western 91.8, northern 40 and southern 40. Totally measuring 3,672 square foot together with 15 squares RCC roof top thereon.
Has your officer inspected this?
Yes, my lord. It has been after inspection only, my lord.
So therefore, according to your office details, it's only a land with a 15 feet road. Shop premises.
There is a building because what
Where's the reference building in there?
RCC.
Where's the building reference there?
Not totally measuring 3,007.
That's a land. That's a land.
With 15 squares RCC.
Correct. 15 square RCC.
Built thereon with cement and bricks. Provided under cement plaster. Lord, what I would like to say, my lord.
Which floor is this? Who's your officer who conducted the inspection? Give his name.
This Lord.
Who's the officer conducted the inspection? Give his name. Ask him to present with along with the documents.
Please. Lord, I would like to say something like this. Lord, the act or statute provides for an efficacious remedy.
No, we understand that. We understand that, but this seems to be something else.
Lord,
that's why we looked into the schedule of the both the same.
Schedule, my lord, what my lord is trying, very senior counsel, my lord, refers to, my lord, this schedule, which he has given at page number 11, is not to be found anywhere.
How many floors are there in the property?
He does not know that. My lord, this schedule here, whatever he states, my lord, in the
3 floors.
Lord,
how many floors are there in page number 212, sir?
Lord, 24 may kindly be seen for a minute.
No, 212, how many floors are there, sir?
ಇದರಲ್ಲಿ 3,672 ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
Correct.
15 squares ಅಂತ ಬರ್ದಿದ್ದಾರೆ. Lord, this is the same date, my lord, which they give to me for effecting change of
Don't you inspect the property before
after
Khata?
inspection, my lord, that is
Correct.
done.
If it is found, it is not there. Give the details of the officer and the records.
I'll try to secure that.
Yes,
In
but
the meantime, my lord, mainly it is sufficient. Kindly, my lord, 24 may kindly be seen for a minute.
24 of what?
Page 24 of the repetition paper.
Yes.
This schedule whatever my learned friend has referred. Schedule A and nowhere to be seen. We don't find this schedule at all.
That's all. That's why we are asking.
Each schedule,
How do Nodi? See,
this schedule.
that's why we asked repeatedly, since both of you did not cooperate, we went on with the schedule analysis. And our reading is this. According to the sale deed of the petitioner, it situates in the second floor. There is a mezzanine floor.
No,
and he purchases.
Document does not say anything.
So let us see.
Does not say anything.
So let us see. So you please give the details as to how many floors the building has.
It says year of construction of the building.
No, counsel, you are not assisting, please. Both of you are not assisting. We will get the details. We will see whether your shop is in second floor or his shop is in the ground floor. We'll find that.
They are not willing to produce.
Let's see that. Barkuli.
But one thing, my lord, what I would like to place on record, my lord, is this: when there is a statutory remedy available to them,
Not case of this.
they have to exhaust that.
No, you can't take shelter under. No, counsel, you can't take shelter under statutory case of this nature.
He is in a better position to assess the entire.
All right, let your officer file an affidavit saying that only this property is existing, nothing else. We'll see what this will be later. If the case of the petitioner is on the wrong foot, he will have to face the music. If he says
what happens is, may I make this submission? May I permit to make this?
Please.
My lord, statute says that a particular act must be done in a particular manner. My lord, he has to exhaust that and then come before this court. Without that, my lord, he cannot directly approach this court. That is what my lord Supreme Court writes.
All right. Barkuli. It is the case of the petitioner that he is the owner of Schedule properties described in the petition. How many properties? Property described in the schedule, having purchased. Enough. Having purchased the same.
But tenant was there.
Having purchased the same. All right. Having purchased the same under how many sale deeds you purchased it under?
5 sales.
Under 5 sale deeds. At exhibit A1 to A, annexure A1 to A to A5. A to A4. All dated 26/2/1994. That 26th and 26th Jan
and also 23rd March.
and 23rd March 1994.
Oh.
94. When did you learn about the Khata change?
We came to know
From 2015, he has not paid the taxes.
That during the year 2022, petitioner learned that Khata in respect of the aforesaid property which stood in his name in respect of the scheduled property has been clandestinely registered. In the name of respondent number 5.
Respondent number 4 at that time, they claim that it was transferred by respondent 4 bought it from 5 and they do not know, they do not say what basis.
No, Khata. Presently, whose name the Khata is standing?
Now respondent number 4.
Correct. Has been transferred in the name of respondent number 4, allegedly on the basis of a transfer effected by respondent number 5, without there being any deed of conveyance. Now, senior counsel appearing for the petitioner refers to annexure Q deed of sale and the schedule of the property described therein, and submits that the property under which the petitioner, the petition property and the property described at annexure Q sale deed are different and distinct, and that the respondent authorities, without applying their mind, have effected the Khata. Counsel for the respondent, BBMP, submits that there is a statutory remedy available under the Act, that is section 114 capital A under the Karnataka Municipal Corporation Act and on section 149 of the BBMP Act. He submits that in view of there being an alternate and expeditious remedy being available to the petitioner, he should be relegated to resort to the same. Full stop. It is seen from the schedule to the sale lead and annexure Q. Schedule B is described as under page 212. On the face of it, the said schedule suggests existence of property measuring 3,672 square feet with a 15 square RCC roof shop thereon. There is no mention with regard to any other portion of the building or the floor, while the property being claimed by the petitioner consists situated in the second floor of a commercial complex known and called as Poshi's complex. Needless to mention that when an application for change of Khata is made, circumstances are contemplated in section 114 of the Act. The counsel for the respondent submits that he would furnish the details of the inspection report and the action taken by the concerned revenue officer before effecting the Khata in the matter by next date of hearing. Counsel to furnish the records concerning the file and also the name of the name of the revenue officer who effected the change of Khata in the matter. List this matter on 8.
Second week, because I'll have to secure the records from him.
82nd week.
Third week.
82nd.
So third week. 17.
14th.
Hi.
14th. Yes. Interim order granted earlier, extended till next date of hearing. Early. We'll see that later. We'll see later. Will not accept it now. The memo of retirement office copy, we will take it later. You can take this memo of retirement, you can file it in the counter. We'll see it later, not now.
Or can I see for an hand delivery of the order so that I can give to the. Now, somewhere you have to send the signal. Yes.
No, this cannot be allowed to happen. Technically, you are very sound, but then the reality, you know well. Somewhere we have to pierce through it. Cannot be accepted. Yes. Yes, handle.
54 of this, 55.
Yes, what is the matter? What is this matter, ma?
Building has constructed without sanction plan, without setback, and without any
What objection? Who are you? Respondent 1 and 2. It's not between you. What are you doing? What action have you taken? So you assisted him to get the status code in the city civil court. We will not consider that. Have you issued the sanction plan? What action have you taken, sir? Tell me. Take action, demolition. That's not sufficient.
We'll actually take action according to law.
When will you take?
No, because what happened, let's say after once that confirmation.
That we are not concerned, sir. Don't give all these reasons. When are you taking action? Tell us that.
What happened? After we have taken the confirmation of thousand, actually opposed to this.
I too, we heard that. Don't repeat it. You tell us when you take action now.
We'll take action.
When? When will you take action? What do you do in 20 days? Yes, work on it. That counts for the petitioner. Then comes for the respondent. Authority submits that they have issued provisional order under section 321, 248 of BBMP Act 2020. And where is the sanction plan, sir? Where is the sanction plan? No date. You should have taken action by now. In Vadira? Under section 248 of BBMP Act 2020. And thereafter, respondent 1 and 2 have approached the city civil court and obtained an order of status quo. Be that as it is, the fact remains prima facie, the building is constructed without benefit of any sanction plan, let alone deviation from the sanction plan, even as admitted by the Learned Counsel for the respondent number 1 and 2. Now, counsel, the respondent 1 and 2 submits the necessary action in accordance with law would be taken, including demolition of the building within 10 days, 20 days, 1 month. Yen gottalla, officer yaar kudi, in whose jurisdiction barodid heli? Who was the officer? We will not talk to him. What was he doing when the building was being constructed? You know the earlier directions of this court given decade ago. Now, what was he doing? Get his service details. Construction demolition cost has to be borne by him. I too, whoever is there in his place also will have to pay. He will also have to pay. Let them share it. The cost of demolition has to be shared by them, not by the public exchequer. What's his name? What due to that? No, don't talk. Don't talk. We are not concerned, sir. You find out, give the name of the person who was there in his place, he and him, everybody have to bear the cost of construction. Adi yavaga, sir? We will see all that. 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 We will answer all that. Nothing doing. Now we'll pass the order, obey this order also. What is his designation? Who was the other earlier person? What's his name? Huh?
His name is
Ismat. Vishwanath. Vishwanath Heli. Who was the earlier person? Tell your Aurigeli. Give the names of the persons. Detail. In brother.
Correspondent number 1 to submit that necessary action in accordance with would be taken, including demolition of the building
within period of 30 days from the date of from today. Third counsel for the DBMP further submit that he will furnish the details of the officers who are in charge of the area to supervise the construction of further orders will pass in this regard. Yes. Kodi date. 30 days. Date kodi. Not 30 days will not give. No, nothing doing, nothing doing. 15th. Do whatever you want. We have seen, you must understand, Mr. Counsel, we have seen the difficulty of the people, houses being converted to swimming pools. And unfortunate people had to face the wrath of the nature and the officers. And nothing has happened to the officers. None of us are drawing any sadistic pleasure here. If they had taken action, the destruction would not have happened. At least now. Let them know the responsibility. At least now on, let them know the responsibility. 15th. Next correct. Password.
Password matters, November 9, Sanjeev BL.
Ask him to keep quiet. Next correct. Number? Nice. 9. Hey. Where is he? In Barthanella, more than I think. We'll dismiss this. If it comes. No, or either a career will take up end of the list 1 hour. Yes. Next.
Number 10.
ಬರ್ಲಿಲ್ವಾ ಅವರು? Party in petitioner being party in person is not present. How will you communicate him? Phone number idea. Communicate. List this matter on dash. Registering to communicate the date of hearing to the party in person. And also apprise him the requirement of filing an application before the party in person committee. Yes. Adana avrige heli. Yes. Date.
It is November.
Yes.
$21.
Kodi. None appears for the petitioner when the matter is called the second time. Enik password agidi or kelidana just after 2 weeks.
$23. Satish Chandra.
Then of the payment of petition. Of course, I have not challenged the notification. Not the challenge. Our one report, our wording is reached in the 2022. 22 February.
Good.
The same goes on reputation and reservation. Is the constitutional validity is completely explained by the.
Correct. There cannot be repetition of roster. No difficulty on that.
In this case also, clearly stated there, clearly stated. There is so many questions are raised. Page number 53 now. Page number 3.
Yes.
I read
Ready.
section in the law. Section 10(1)(a) of the Act and rules made therein. Though the learned Advocate General vehemently argued by relying upon the statement indicating the rotation of post of officers of mayor and deputy mayor of corporation. However, the said rotation of posted do not have statutory recognition. It is also to be noted that the said statement indicating rotation of posted for the office of mayor and deputy mayor of corporation cannot be override section 10(1)(a) of the Act, as well as Article 243 of the Constitution of Congress. It is state law that no notification, circular, instruction, etc. shall run counter to Article 243. According to this law, they are not medically challenging the 2021.
Whether the 2021 notification part of this?
Yes, it is also there.
Alla, idರಲ್ಲಿ ಇದೆಯಾ ಈ ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ ಈ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ಹಾ ಎಲ್ಲಿದೆ where is the reference to that? Where is the reference to the notification guidelines?
First of all, page number 241. ಇಲ್ಲಿಯೂ ಸಹ ಅವರು ಆ ನೋಟಿಫಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಆ ನೋಟಿಫಿಕೇಶನ್ ಹಾಕಿದ್ರು ಸಹ ಕೋರ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡೋದನ್ನೇ ಆ ನೋಟಿಫಿಕೇಶನ್ ಇದು ಮಾಡಬೇಕು. ಲಾಸ್ಟ್ ಇದರ ಪೇಜ್ ನಂಬರ್ 42.
Yes.
Page number 62. The pronouncement to court referred the above, therefore, the improved notification 27 January 22 is bad in law. For reasons stated above, the same is contrary to Article 243F and 243B of the Constitution of India. I am view of that argument advanced by that 6th November 2021 notification.
Yes.
Under all these earlier notification, 2021 notification is also referred by the Honorable Court and clearly stated in all the terms of reply and all the submission is made by the government. And that notification is to be passed by the own.
Pass ಮಾಡಿದಾರಾ?
Pass ಮಾಡಿದ್ರು.
ಪಾಸ್ ಆಗಿದೆ ಮತ್ತು
notification UDD MLR 2021 dated 11 February 21 page number 6. Petition 2022.
ಯಾವುದು annexure ಅದು?
64 page number 6.
Correct. Annexure release number
A
of that notification 11th February 2021.
MLR
Which is the notification? ಇಲ್ಲಿ ಯಾವುದು guidelines ಇದು? Where is that?
Even notification 27 January ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನು ಪಾಸ್
It is after. Yeah. Okay.
for the and Aziz case, rotation, all the things is explained by the body.
Yes. What was the stage when the interim order was granted in this matter?
In this earlier, earlier, the first notification on 24/3/2018, I filed it.
24?
Earlier notification is 24/8/2022.
Yes.
First notification is withdrawn and quashed by the sum. Withdrawn. Subsequently, redo the same by the honorable principal secretary. The another notification was done by 29/9/2000. As on that, first DCA was to be given the, and second is to the SC was to be.
Now this notification 29/9/21. Where is it? Where is it? 22? Objection to Kana.
Amendment petition.
ಏನು amendment ಆಗ್ತಿದ್ದೀರಾ ತಾವು?
ಅಲ್ಲಿ ಫಸ್ಟ್ ನನಗೆ ಹೆಂಗ್ ಮಾಡ್ತಾ ಕೇಳಿದ್ರೆ ಅಲ್ಲಿ ವಿಡ್ರಾ ಹೋಗಿದೆ ನೆಕ್ಸ್ಟ್ ಎಲ್ಲಿಗೆ ಆಗ್ಬಿಟ್ಟು ಅದೆಲ್ಲ ಅಲ್ವಾ
This amendment application is allowed?
allowed petition.
Ah.
Amendment petition is to be filed for 500.
Ah. No, that notification provided for what? You read in the list. That is not quashed. Now the present election is as per that list. No. Earlier notification 24th August 2022. That is set aside. Thereafter, you issued a revised notification, which is 29/9/20. So that is under question now. So the present election is being conducted based on this.
Yes, is only this sum of what is to be directed to both respective matter until to the disposal of the matter in the same is to be order.
When was that? When is that order?
30/9/2022.
Order agidya adike?
And the board respect the order agilla. Application for amendment for the petition and
30th?
petition placed on record. This is not a fixed election to the court of nearly subject to the outcome of this petition.
Until already. The same order will continue.
What is possible in the election?
Correct. Election to the post of mayor of Shumaga, that's what Kumar was going to conduct it.
Yes, sir.
Subject to outcome of the writ petition is already.
You know, the election, I don't.
It will be outcome of the writ petition only.
I'm ready to understand the state of election process.
Sir, tell us, now once the calendar of events are issued,
No,
can you interfere?
No.
Correct. Whenever it is issued, can we interfere in that?
Because there is a matter is undertaken directly to don't respect the matter.
Ellide ado?
Adon orally here. In usual course, you don't respect the matter subject to this condition. Afterwards, the petition would be for the vacation. Vacation bench is also not.
Which means the courts have deemed it appropriate not to mention.
I'm also.
Correct.
I'm not. I'm not ಬರ್ಸಿಲ್ಲ
ಅಲ್ಲ ಬರ್ಸಿಲ್ಲ ತಾವು ಬರ್ಸ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ತಾವು ಬರ್ಸ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. You can only request and make out a case. ಬರ್ಸಿಲ್ಲ ಅಂದ್ರೆ ಬರ್ಸ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. So ತಾವು ಹೇಳಿರ್ತೀರಾ. Yes, the order is already there. Election to the post of mayor, Shumaga is municipal corporation subject to outcome of the petition. Ready for final hearing. Happily, list this matter. This court.
Election
No, you can't interfere. Election agli, we'll take it for final hearing, final disposal. Pleading ಎಲ್ಲ complete ಆಗಿದೆಯಲ್ಲ ಅದ? Pleading ಎಲ್ಲ complete ಆಗಿದೆಯಲ್ಲ ಇದರಲ್ಲಿ? ಏನು amendment ಹಾಕಿದ್ದೀರಾ? ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿಕೊಡಿ. We'll take up this matter. By order dated 30/9/2022, this court has already passed an order to the effect that the election to the post of mayor of Shumaga Municipal Corporation is subject to outcome of this writ petition. Full stop. Now, counsel the petitioner insists that the elections are scheduled to be held tomorrow in terms of the guidelines dated 22nd February 2021, which have already been set aside by the coordinate bench of this court in writ petition number guidelines re-notification writ petition number 20. At the time in case has been set aside, then your case. ತಾವು ಹಾಕಿಲ್ಲ ತಾವು ಇದನ್ನ ಕೊಟ್ಟಿದ್ದು ಅದೇ ಹೇಳಿದ್ದು ದಟ್ ಗೈಡ್ಲೈನ್ಸ್ has been set aside ತಾನೇ ತಾವು ಹೇಳ್ತಿರೋದು. No, you have issue. No. One second. ಕೇಳ್ಕೊಳ್ಳಿ. The notification, revised notification dated 29/9/2022 is issued by you pursuant to the guidelines of February 2021. That notification, that guidelines has been set aside by the coordinated bench of this court in writ petition number 202488. Correct? ಅದೇ ಅವ್ರು ಹೇಳ್ತಿರೋದು ಅದೇ ತಾನೇ. ತಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ತಾ ಇಲ್ಲ, ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದೀರ ತಾವು. ದಿಸ್ ನೋಟಿಫಿಕೇಶನ್ ಉಂಟಲ್ಲ 29/9/2022, this is issued according to the government as per the guidelines of February 2021. That guidelines according to you has been already set aside. ಅದೇ ನೋಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ. 202488 of 2021 and petition number 200346 and 200347 of 2022. Therefore, he submits that there is a need to stop the process of election intended to be conducted, process of election scheduled on 28/10/2022. Full stop. Submission taken on record. As already noted, above, this court has already passed an order to the effect that the election of the mayor would be subject to outcome of the present petition. In view of the fact that the pleadings have already been completed, and also in view of the fact that the guidelines pursuant to which the present notification appears to have been issued by the respondent, matter request to be heard. Finally, list this matter on. ಹೇಳಿದೀವಲ್ಲ ಕ್ಯಾಲೆಂಡರ್ ಹೇಳಿದಿಲ್ಲಮ್ಮ ಏನ್ ಬಂದಿದ್ರೆ ಕೊನೆಗೆ ಬಂದಿದ್ರ ಮೇಲ್ಗಡೆ ಅದಕ್ಕಿಂತ ಮೇಲೆ since the calendar of events have already been issued, it is just and proper that the process of election be gone on subject to outcome of the petition as already noted above. I'll list this matter for final disposal on Monday. Yes. ಮಾಡಿ ಏನೇನ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ಬಿಡಿ ಅಲ್ಲಿ ಮಂಡೆಗೆ ರೆಡಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ. If the notification guidelines is already set aside, what remains? You should have brought to the notice of the court, government. The entire basis of your notification goes. No, you have redone the list, but again based on the guidelines which is already set aside. Then what happens to the guidelines and the notification? It also has to go. Think about, up to you. Up to you. You want to conduct the election, conduct. Result is here now. You must advise them properly. Entire expenditure go down the drain. It's clear. If you had assisted long time back, matter would have been disposed of by. ತಾವು ತಂದ್ಕೊಟ್ಟಿಲ್ಲ, ಇವತ್ತು ತಂದ್ಕೊಟ್ರೆ ಅದನ್ನ ಮೊದಲೇ ತಂದ್ಕೊಡ್ಬಾರ್ದ? That order setting aside notification. All right. Yes. Monday. ಅದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದು, ನಾವು ಹೇಳಕ್ಕಾಗಲ್ಲ. If they have material and everything, they will go ahead and redo it again. Number 24. Yes.
It is the provision of no compensation part name, which is and anyway to take the
Yes.
Usually, all appropriate order. But I think the provision of no compensation contain provision 49 is on word and Karnataka is ineffective. But suppose the president or vice president of the all of the and there is only one elected member without which there is no category among the members of the government. And consequently, that private cannot be voted against.
Where is the provision, constitutional provision for that?
It's important.
Where is the constitutional provision for that?
In the light of this. Not very.
Assuming this case is genuine case, this may give a free hand for other cases. Then.
And the Ram Swaraj Act provides for reservation. And in fact, the 73rd amendment when the Ram Swaraj was incorporated specifically in the Constitution. Article 243B provides for reservation to SC/ST and also to backward classes. And in the light of this, section 44 it gives words and the light to the constitutional provision.
Intent of the Constitution.
It says the deputy commissioner in each district, he shall provide a reservation. Reservation is provided for, and reservation is as per the constitutional mandate. Now, what the question is, now one reservation is provided for a particular period. Now the period is 30 months. The term of the president now is as per the amendment, president and the president is 30 months. And as far as no confidence motion is concerned, it cannot be moved within 15 months. Now the situation is this: first 15 months is there. Even if it is only for the person belongs to SC reservation, only one person is SC. 15 months is there, but reservation extends to 30 months. Reservation period is 30 months. Reservation for SC is provided for 30 months.
Where do you find that?
The order reservation has been provided.
No, reservation to the post is there, but how do you say it is for the 30 months? Yes.
ಐದು ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನಕ್ಕೆ ಚುನಾವಣೆ ನಡೆಸಬೇಕಾಗುತ್ತದೆ. ಈ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಆಯ್ಕೆಯ ಸದಸ್ಯರಾದ ಕಾಮಗಾರಿ ತಿಳಿಸಿಕೊಡುತ್ತದೆ. ಐದು ಗ್ರಾಮ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷರನ್ನು ಚುನಾವಣೆ ನಡೆಸಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಡ್ಯಾಶ್ ಪ್ರಕರಣವನ್ನು ಗೊತ್ತುಪಡಿಸಿದ್ದಾರೆ ನೇಮಿಸುತ್ತಾರೆ. ಆದ ಕಾರಣ ಸಭೆಯಲ್ಲಿ ಕರೆಯಲಾಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ನಾಮಪತ್ರ ಅದು ಬೇಡ. ನೆಕ್ಸ್ಟ್ ನಾಮಪತ್ರ ಪರಿಶೀಲನೆ. ನೆಕ್ಸ್ಟ್ ದಾಖಲೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಅವರ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಡ್ಯಾಶ್ ಸಂಖ್ಯೆ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ಈ ಕೆಳಗೆ ಕಾಣಿಸುತ್ತೆ ಮೀಸಲಾಗುತ್ತದೆ. ಅಧ್ಯಕ್ಷರ ಸ್ಥಾನ ಹಿಂದುಳಿದ ವರ್ಗ ಬಿ ಮೇಲೆ ಕ್ವಶನ್ ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನ ದಿಸ್ ಇಸ್ ಇಲೆಕ್ಷನ್ ನೋಟಿಸ್. ನಾವು ನಂತರ ನೋಟಿಫಿಕೇಶನ್ page 22.
Yes.
This page is immediately and now at the top my lord ಕ್ರಮ ಸಂಖ್ಯೆ ಗ್ರಾಮ ನೆಕ್ಸ್ಟ್ 2020ನೇ ಸಾಲಿನಲ್ಲಿ ನಿಗದಿಪಡಿಸಲಾದ ಮೊದಲ 30 ತಿಂಗಳ ಅವಧಿಗೆ ಮೀಸಲಾಗಿದೆ. ಮೊದಲ 30 ತಿಂಗಳ ಅವಧಿ and training is not with serial number 7 ಐದು ಹಿಂದುಳಿದ ವರ್ಗ ಬಿ ಮೇಲೆ.
No, correct. Under which provision it says that the 30 months period should be considered as the reserved period without any disturbance?
Section 44 it's up to them to fix the time. Once they fixed it,
whether section 49 is controlled by this notification or 44?
whether 49 would lead to section 44 or not. That's the question which you are asking now. But there are applications. The 49 million is also coordinated million and also on the million is started earlier. Section 44.
Yes.
Election of adjudication and upadhyaya. Every Gram Panchayat shall within 1 month from so and so choose a president and a vice president. That's what we are doing. Subsection 2, provision for reservation. Subject to the general or special order of the state election commission, the deputy commissioner shall reserve such number of office adhyaksha or upadhyakshas in the state for the scheduled caste and scheduled tribes, and a number of such officers varying as nearly as may be the same proportion to the total number of officers in the state and the population scheduled caste in the state or of the scheduled tribes in the state, varies to the total population. Next, provided no person belongs to scheduled caste is available, is not so and so to be filled by person belonging to scheduled tribe. Next, B. Such number of adhyaksha or upadhyakshas in Gram Panchayat shall be as nearly as maybe 1/3 of the number of adhyaksha or upadhyakshas in the state belonging to backward caste. But the number of officers of adhyaksha and upadhyakshas reserved for backward caste will determine total number of officers of adhyaksha and upadhyakshas reserved caste and a scheduled tribes and a backward caste. So will not exceed 50% of the total number of officers of adhyaksha and upadhyakshas of the Gram. Provided that the office is reserved under this clause, 80% of the total number of such offices is reserved for the persons falling under category A. The remaining 20% of the office falling under category B. Provide further that there is no person falling under category A. Office is reserved for that category. B. Next, not less than 50% of the total number of this important. Adhyaksha and upadhyakshas A. Each category is reserved for persons belonging to scheduled caste, scheduled tribes, and backward classes. And those of which are non-reserved for women, subject an overall limit of 1.5 of the total number, rounding off next number. Because petition here are the woman, big woman, male. Provided the office reserved in section can be allotted the rotation different Gram Panchayats. My last question to me, the period. When the deputy commissioner has fixed the period at 30 months in the present case, and it is not only for this Gram Panchayat. I am told the subject correction from the state by lot what they have done it. From the state, what they do is by lot, because SC, ST and other backward communities and plus women, they have to be accommodated. They cited. My information is what they have done is total 60 months by lot. 30 months on spot and 30 months second spot will be released. This happened election in the present case to the Gram Panchayat by lot because in 20 December.
Yes.
Then 20 December. And date election to the post of the president is 18 to then 21. Anyhow, the 26th is December, then 20. That's how they have done it. Of course, they can do it in other manner. Probably the reason for this is 30 months, the reason is by lot. Now they have amended. Earlier by lot, so it was 5 years, president then made 30 months. So
yes.
I feel subject to but my lot is the period of 30 months is because now the period of the term of the chairman is made as 30 months under the act.
No, whether the election commission has authorized the DC to fix the date period.
My lord, this aspect is concerned, my lord. I'm not aware of the.
31/3/2020. 30 days. Now it is reduced to 15 minutes.
Correct. But that amendment is made.
Section 49 amendment is okay. That's as far as bringing the.
No confidence motion is concerned.
But as far as the post is concerned, my lord, the period is concerned. That is, they are not having 46, section 46. But term of office, conditions of service of adhyaksha and upadhyakshas.
Yes.
Term of office, the very adhyaksha and upadhyakshas, initially 5 years, now I have told amended to make it as 60, 30 months.
30 months now.
30 months. 30 months. So what they have done is, term of office of the adhyaksha throughout the state is 30 months. So for 30 months, they have provided reservation throughout the state. Now, after 30 months, the second spot of reservation will come. Now, the situation is this. This provides 30 months. As far as moving no confidence motion is concerned, what they have not done is, in 15 months, no embargo is there. And after 15 months, no confidence motion can be moved. No difficulty will arise where person belongs to the same reserve category, there is more than one person in there, there is no difficulty. Because there can be the other person who can come to power and even this person can contest. One more aspect you not make any person again who no confidence motion is good. There is no disqualification for him to contest again. Even if he is out of office on account of no confidence, he can again contest. Of course, one theoretical and argument can be advanced by law. In this case, our argument is she is the lone member belonging to the reserve category. And what should happen? Theoretically, what can happen is they can move the more confidence.
If he loses, there will be collection again for the post. There is no embargo for you to contest. There is no embargo for you to contest. You can contest.
She has to be elected unopposed. Because it should be because of more the candidate.
Correct.
That happened in the first election up to the present case. On 2021, the election officer votes. He is the only person available.
All right. Yeah, even as per section 44, if that candidate is not available, the other provision given. Yes.
Scheduled caste is available. Scheduled caste is available.
So other would come. The next in line will come.
How? It belongs to backward.
All right. In the rotation, who the next will come?
There is no such thing provided and that is not visible. The period is 30 months. As a scheduled caste, that provision is made. Scheduled caste is not a scheduled tribe.
Yes. This is what category?
It is other OBC.
OBC ಬೇರೆ ಯಾರಿಲ್ವಾ?
The OBC.
PLOD, such number of office Abhyaksha of the Gram Panchayat, which shall be nearly as 1/3.
But the number of offices adjudication and widening the results of that status, the this God shall be before it, the number of offices result of the schedule class and the schedule, right? Under clause A of the backward class, this clause shall not exceed 15% of the total number of offices adjudication of the Gram Panchayat.
Yes, provided again.
Provided that the office results of 80 can be subject to general or special order and election reserved by the deputy for the person falling under the category and the next.
Again, second proviso takes care of that. Second proviso takes care of that. Provided further that if no person falling under category A is available, office reserved for shall be for B or vice versa. Now you fall under which category?
Woman B category.
All right. If there is no category A, B will come. If A is not there, B is not there, A will come. Vice versa.
No person is available. She is available. It's technically not technically. The reservation is provided for B category. No person is available in B category.
All right. It's not A category.
Yes. That's not happened in this case because at any event, the only question the presentation is available. Now the question is for fulfilling theoretically an exercise by God, should this be allowed? That is the question.
It has to be allowed. Provision doesn't give an exception there. Yes, yes. Yes, yes.
Election process, we commenced for electing an adjudication of the company. To contain the one from the apparent is that one Srimati had been elected as the adjudication of the company. He belongs to the tribe. Post of adjudication is reserved for a woman ST candidate. In terms of section 44 of the Act, only don't agree about the challenge the validity of the said provision that it renders section odious. But in the situation one, there is only one person. Therefore, others will be allowed to contest. Once and no comment motion is moved, he is not allowed to contest. That was the argument, of course. The argument is contrary to.
Yes, yes.
But the wording is the same. See, six plus one that elected the Adhyaksha of the Panchayat. She be the only one expelled. If no other motion was brought against her, resignation of grant, second one was totally. Separate proceedings have been initiated before the court telling the related resolution, etc. Now, the other process that the Karnataka Panchayat to take democracy to start with. The Panchayat has to thus there is rule of the measure. Consequently, the majority had expressed one of the process action and the same terms as provided friend would lead to nullification of that process. Therefore, he reduced the whole process to water it down. He emphasized it is not the intent to legislate at all. He also carried against an often better to allow the to contest again with the certification of government. Therefore, allow section 44 to work in the face of the resolution of section 49 would render 49 useless. That was the remedy. Another submitted that the steps taken to respond are in terms of as long as the civil that is not qualified or that was submitted is good. Should not interfere in the process of election. He pointed out the other equivalent as whether there is any provision that preclude barring a person against whom no government moves. Test by resolution contest for the same office that is. The non-circumstances there is no reservation. Learned counsel is not in a position to revision. If the normal circumstance there is no bar against whom no government moves, then contest that and it is very confident of winning the election there. Why such a person cannot contest the election beyond our understanding? And such a can hardly can work. Therefore, we can use the role of next parent level for my submission. It is clear that we should also notice the very difficult impact results it could lead to if the provisions of the enactments are given in respect to under section 42. Reservations are given to persons belonging to caste or community, and such reservations are considered to be proper, bearing in mind that the posts were never held by such persons belonging to the caste. It cannot be forgotten that reservations made to protect such persons must provide further that no content motion could be moved only in the certain circumstances such as disability arising on account of serious misconduct of the movement in office. Especially on this matter, that in division which holds that where reservation is provided to such situation where there is only one candidate, I should further provide can be removed only on account of disqualification. Otherwise, the moment he can be on the next day, because he doesn't enjoy the confidence of everybody. He is that in office because he's the only person. If there are multiple persons, may not be the entire government. The honorable is clearly laid down that legislation should provide for us. Take every people only on this. Otherwise that provision stand, that may lead to different situations such as the present case as if a person who no comes to exercise and is elected again to the office, such person is not in a position to command majority of the country. Celebrated government statement. Legislature will have to control its attention to this aspect. Suitably provide for such contingencies. At this moment only, this is the law. It's right now. No,
it's not the law, it's observation.
Observation.
An observation giving to the wisdom of the legislature to do the needful.
Before that, reservations made to protect such persons must further provide. That's the word issue. Provide. This was in the year 1980. And they are provided for. Can we see section 48? Section 48. Resignation or removal.
Yes.
The first part provides for resignation. Resignation is my lord 48, subsection 1, 2, and 3.
Yes.
Resignation.
Yes.
May take on to go to subsection 4.
Yes.
Every adhyaksha and upadhyaksha of Gram Panchayat shall, after an opportunity is afforded for hearing him, and if necessary, after obtaining a report from the Panchayat and considering we remove.
That is with the government. That's removal with the government.
Yes, that's what I'm saying. This conduct we can do.
No.
I'm submitting, right? line of arguments before my wife.
That is in the absence of invoking section 45.
Please.
Removal will come if there is no confidence motion moved by the members.
My lord,
Government cannot mute spectator. If it comes to notice the government that all of them hand in glove, nobody wants to remove the president. The government for misconduct, government cannot sit. The government said, come on, you all seem to be hand in glove, let me take action. As you have ever seen a concept, the power of no confidence motion is a right given to the members.
yes. No reason be assigned.
No reason be assigned. If you command the confidence, you can always win.
Yes. I never command any confidence from the figure. As far as you can appreciate the situation. As far as one hand reservation is provided, it can never be coupled with a condition.
So therefore, you see, if you look at this situation, therefore, the minimum period is fixed.
30 months.
Earlier 30 months, now reduced to 15 months.
I beg to submit 30 months. Earlier it was 5 years, 60 months. I thought the post is done.
Therefore, no, even to make a mention of no confidence motion, minimum period is mentioned. A person, look at the situation. A person who comes irrespective of the category which is elected can be honest, can be dishonest from the day one.
Can be honest or can be dishonest?
From the day one till the end. But there should be limit for it. If you are dishonest, we will give 15 months time for you. Right? So you can continue to dishonest from the moment go for 15 months. Not tolerant beyond that. You can be honest for throughout your life. That's a different matter. But then that would not inure to the benefit to say that I would continue to be honest and dishonest for the entire term. Nobody can trust me. No. That interpretation cannot be given. Yes. That would run contrary to the democratic process. It will strengthen the hands of, I mean, we don't know about your client, but then strengthen the hands of those people who come under the name, it's not, see, reservation, yes, it's a constitutional provision to give opportunity to everyone, fine. That opportunity does not mean that you misuse that opportunity.
Not enjoying the conflict. Now, these two are now not connected. Fishing for this reason. 49.2, they brought in 49.2 amendment. 49.2, they deleted it. One of the reasons for deletion is, as a misconduct is concerned, a necessary inquiry has to be.
Correct. So therefore, the government will take care.
Misconduct, my lord, is done the no timing. The proceeding can be any time. That's what I submit. 49 does not in any way govern 48, my lord.
Correct. That's independent.
Independent. And one more reason is
because there also, as we just observed, from day 1 to 15 months, government also cannot be mute spectator.
Yes.
So therefore, that plenary power is given to the government even before 15 months.
15 months after inquiry. That is said.
As regards the members are concerned, 15 months.
15 months. Now, my lord, adding report. Yes, because that means to the maximum.
Correct. Should be given. It affects your right and reputation.
All those things have to be followed. Otherwise,
yes.
It is stigma.
Correct.
48 takes care of that situation. Whether 49, we have to every situation which you are not may kindly decide, having the spirit of the reservation being provided. Now, kindly appreciate that this acts are concerned. What are the delegation? Also, the last may is because I am coming to the under the report under the relief, my lord.
So on this point, this only judgment you refer to is this.
And second one is also.
What the second sir?
1996 judgment was passed, my lord. These are the judicial. Again, identical situation came into the 9th. Actually, gets the 9th.
Yes.
There the situation was, my lord. Page number 40. 15 out of the 19 members agreed by the notification that is planned to convening the meeting to hold elections in the that situation is there, my lord. What happened was no condition was moved. Again, election was being held. The 15 members said, de-reserve, cancel the reservation. And this honorable court laid down. There are two main reasons.
Yes.
According to the petitioner, both respondents being the only member elected the membership of the franchise, reserved for children, right? When elected to the office of the center is so and so, also reserved for children, right? Though ousted from office for want of confidence, would be elected, unopposed, to the head office, once over, without a position of command, majority. The petition contains the court response having committed serious irregularities. In that case, my lords, there are irregularities. And then, can you see paragraph? Having heard the learned counsel for the petitioner, who reiterates the evidence set out in the petition is no doubt true. Attempts to disclose a frequent situation since a person in whom no person was expressed would be elected again to the very office. There is a no. Though not in a position to command a majority in the panchayat, it would lead to a stalemate in the panchayat in identity of the put in Bapudala by pointing out situation, observe that who was legislated to attention. Today, amendment. Next, it is a matter of fact that also 30 years have gone by since the appropriate observation. So nothing precious is done by the state. It is hoped that the state would open its eyes and bestow its attention in that regard. Now, contention that the court respondent ought not be permitted to conduct election to office for and to third person, right? And that reservation of the must be cannot be countenanced. Now, my lord started with the revision with observations, my lord, and then with the hope. This is an exact question. In interpreting the provisions, I respect in some way, this has to be taken note of. The spirit within this order to begin with based on something that is 1996. Now, my lord, almost 25 years have passed, and the second observation is made in almost 13-14 years have passed, my lord. And still, whether the government has done or not, legislation has done or not. Now we are asking the legislation doesn't do it. Because the effect is this, my lord. No government motion is moved. Again, I am entitled to country. What the government can do is, of course, on account of political consideration, what they can do is, if I am not belonging to a particular political party at the difference, they can delay the election. That's another aspect. The honorable court will certainly take care of that. But otherwise, the situation is, if a grammatical or literal interpretation is given, situation is, no government motion, election, test again, contest, it's in fact useless exercise, not a fitter exercise. Therefore, satisfy the written meaning of a provision. The court will never think to be done. It is used as time, agree, possibly, etc. That will never be allowed. We have a situation particularly because everything is they can move misconduct against me, move the allegations if there is allegation of misconduct that can be moved. And if it is a vague allegation just saying that he has misused the office, not sufficient, which section 48 will answer. They can move on to 44 now. Now 49 and 44, which should lead to the other. Is the question which my lord may decide. Incidentally, also we need to see what is allegation against me. Kindly see the no conflict motion my lord's letter connected in the type of which attribute Actual Ramada would Panjat not circle. So, I attention as someone. The election is one line. Where it is my only audio there will be no, there is not any confidence in the first day because they belong to a different class or the middle class or the middle class, my lord, who do not enjoy unless one more candidate. They may argue to one candidate now with the other candidate at another time. However, legislature does not specifically provide for answering this situation in spite of repeated, my lord, it can't wait on the written good. In such a situation, my lord, in interpreting whether law is silent, the law requires some reason how to have it out or the writing is built up so that the spirit is answered. And then the constitution court function of interpretation in the light of the constitution comes into play. And the submission is now what is the constitution principle according to the law. Now, as far as one is reservation, the other is
This is not the case of interpretation. This is the case of substituting the view. It is not a case of interpretation. It is a case where, according to you and according to observation made by the division bench also, when there is only one candidate of a particular category facing the no confidence motion, even if loses the no confidence motion, can still contest for the same reserve candidate position, which obviously results in he being elected. That being the situation, why go into this futile exercise? The only question. It's not a question of interpretation. See, we can understand if there was an interpretation ambiguity to clarify that, but now it warrants a provision itself to deal with the circumstances where the case of this nature, where you have only one candidate who will have to go through this academic motion and again come back to the same position, is unwarranted. That does not amount, it's not a question of interpretation. That's required.
That's all. In the prayer column itself, my lord, but you are praying, my lord.
Yes, what do you say on this? Four of
48.
4 of 48. Huh?
Then after an opportunity, the court of hearing and necessary of paying the report from the fact. If it does, that is the situation also that the government will act. So,
But now the question is about no, that's not about 4 now. The question is about now with regard to the no confidence motion. All right, if the no confidence motion is also moved and the petition is removed from the post, you are going to hold no more election. What happens in that? No, but it's a reserve category. And you don't have any other candidate. That is, no, that is.
This is the mistake you want to say. The matter was a particular argument for the Supreme Court has answered. Remember, even a single person who is exposed to reserve.
No, you may not conduct the election. You may continue the rest of the period for the vice president. But you will have to hold the election also.
The election will be conducted. The term of the office of the president is now it is 18 months, 15 months over. Even if it is 30 months, now 20 months are over for the president. Here we have a single candidate who is in the office and it is reserved for a particular category. They cannot misuse the position, cannot misuse the post. That is what the main intention. The 9 persons who are against the president, who is not listening to the elected members of the other members. Obviously, they have moved an application before they discuss.
No, that's not the question. Question is you have only one candidate.
That is only they say, that has to be decided by the government and the.
Who are you?
I am other members.
So you should know who are the other candidates.
There are lady candidates.
Who? Annexure D. Page number
7.
7 of what?
7 of the repetition.
Page number 7 is the repetition. Yes. Shamala is the president, petitioner here. Shamala is the petitioner here.
Yeah, not the petitioner.
Yes.
Rohit, VM Kudian, Manamohan Godiadi, Jayalakshmi, Prema, Dhanalakshmi, and Yesha, Vatsala J, Usha, Adesha.
So this is she's for the backward.
This question is they are entitled, of course, denying governments.
No, she's a backward class B category. Who is the other candidate available for backward class B category here?
We have given a specific pleading record. Apart from this petition, there is absolutely no other.
Yes, you file your details. Find out who is the other candidate.
Yes, the problem here is that the term is now the 6-month period is coming up.
If you are able to show there is another candidate available, petition goes.
I will withdraw.
He will have to withdraw. Which is the judgment you are holding in hand, Supreme Court?
Bhanumati and Vishaka.
Huh.
Those cases was because the local can be moved where the reservation for NCR estimate. That is the question. But yes, no, even for record also it has been answered. Yes. And I agree.
Yes. All right. Saturday. ಹೇಳಿ ಯಾರು ಇದಾರೆ ನೋಡಿ. ಇಲ್ಲಾಂದ್ರೆ we have to give reasoning for this. The request of the Berkeley heard loud senior counsel Hegde appearing for the counsel of the petitioner. He submitted that the petitioner is the only candidate in the category of backward class B, woman, and there is no other candidate available in the said category. Full stop. The petitioner having been the post of the Adhyaksha having been reserved for a period of 30 months could not have been shortened by adopting means of no confidence motion. Full stop. Now counsel for the contesting respondents. Now implead ಆಗಿದ್ದೀರಾ? Now counsel for the impleading applicant. ಯಾಕೆ ಅವ್ರಿಗೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನಾವು? Respondents. No, you will have to get them. It's a no confidence motion. You will have to implement. IA number, accept the cost showing the affidavit accompanying the application, IA number 1 of 2022. Proposed respondents are permitted to come on record. Petitioner to amend the cost title. And counsel for the proposed respondents who are now arrayed as respondents to furnish the details of any other candidate falling in the category of backward class women category. List this matter on OBCB woman category. List this matter on. Yes. Saturday. Monday. Monday. With the citation. Reading it. Yes.
Number 36. Please come.
ಬರ್ಲಿಲ್ವಾ ಅವರು? They did not come. This is also case of delay. Present petition is filed seeking following relief. The case of the petitioner that the land bearing survey number 161, old survey number 70, measuring 1 acre, situated at Baradi village, Kasba Hubli, Nalamangala Taluk, Bangalore, was originally granted one Srimati Venkatama, Jabalaya, in terms of Darkhas bearing number DCD.17/1948-49. So they said Jabalaya passed away, leaving behind his wife, Srimati Venkatama, whose name was mutated in the revenue records, wide number IHC 97 of 1984-80. He said legal representative of the original grantee, Jabalaya, executed a deed of sale dated 15/11/1995 in favor of one Sri Rajanna, the husband of the petitioner. Here they said Rajanna passed away. Consequent thereon, the name of the petitioner was muted in the revenue records. That one Sri Mara Hanumaya, claiming to be the legal representative of Jabalaya, initiated proceedings before the respondent, first and third respondent, alleging violation of provisions of Section 4 of PTCL Act in the proceeding bearing number PTCL.SR.(NE) close the bracket number 26 of 2007-2008. Which proceedings were contested by the petitioner hearing. By order dated 17/1/2011, fourth respondent allowed the said application, directing assumption of the resumption of the restoration of the said land to the original grantee, a legal representative of the original grantee. Agreed by the same, petitioner filed appeal before the third respondent in LND SCST bracket A 72 of 2010-2011. On the premise that disputing the very claim of the legal representative Jabalaya that they belong to SC/ST community and that the alienation in their favor was prohibited under the Act. Limitation began Hedilali. Also on the premise that the original records were not produced. However, the said appeal also resulted in dismissal by order dated 21/2015. Being agreed with the same, the petitioner is before this court. Now, accounts for the petitioner reiterating the grounds argued in the memorandum of petition submits that the legal representatives of late Jabalaya did not produce any acceptable material evidence to establish that late Jabalaya belonged to SC/ST community. Also contended that alternatively, and also that the original grantees did not produce the grant records. It also contended that though the land in question was granted in favor of Jabalaya on 10/5/1949, the sale deed was executed by the wife of said Jabalaya in favor of the husband of the petitioner on 15/11/1995, which was challenged by the grandson of Jabalaya on 17/11/2007. After a lapse of 12 years from the date of execution of the deed of sale. And counsel further submits that in view of the law laid on the apex court in the case of Nekkanti Adaki, the the petitioner is entitled for the relief in the nature of setting aside the order passed by the respondent number 2 and 3. Though sufficient opportunity is given to the respondent, there is no representation on behalf of the respondent or his counsel. There is no representation by the respondent or his counsel. Third, there is the records. It appears that the subject land has been granted in favor of Jabalaya on 10/4/1949. And upon his demise, name of his wife has been muted in the revenue records. The said legal representative of Jablaya executed a sale deed on 15/11/1995, conveying the settled property in favor of the husband of the petitioner, which conveyance is questioned in the proceedings initiated under the provisions of PTCL Act on 17/11/2007. She is a party. Vendor is a party to the proceedings. What's her name? Chennam. She is the vendor. No. You're vendor. You're vendor.
Another person not claiming that he is also one of the legal representatives of Jablaya.
When did he come to know about the sale?
But he is the petitioner brought before the assistant commissioner. Actually, we have page 41. And he claims not that he is the legal representative of the one.
Correct. When did he come to know about the sale?
We never said anything of that.
Though the proceedings, under the provisions of PTCL Act has been initiated by one Elagayana, fourth respondent, claiming to be the grandson of original grantee, disputing the deed of sale dated 15/11/1995 on the premise of the sale was contrary to the provisions of the PTCL Act. No proceedings, no material has been brought on record to show as to the date on which he learned about the execution of deed of sale. Since the said person, our Yuridara, that lady is there, vendor?
She is not available. She did not choose to challenge it.
Anything about her whereabouts?
She doesn't.
No, she does not choose to appear, meaning was she?
She did not file application at all challenging it.
Is she alive?
Only they not that this the approach the state commissioner not be not related to the blame. With the total not stated for family.
What evidence have you laid on that?
Disputed the relationship.
Where does he say that that lady has sold the property to you?
Jablaya son and legal representative. Not all the persons not executed the slip that they dated 15/11/1995. But you also could find at page number 19 on actually. And this particular person not was the state commissioner, but is not a vendor, is not at all related to that family.
Who executed it to you? Wife and?
Has been sold by son and minor children of Jablaya. Son and grandson.
Not the wife. Yes, main brother. Second paragraph.
No material has been brought on record.
First, second paragraph. After the demise of Jablaya, second paragraph.
It appears that the subject land has been granted in favor of Japan 10/7, and upon demise, the name of his wife has been mutated in the revenue.
Wife Allah. The name of his son Allah, Marahamaya. ISC 97 Alva.
The state LR of Jablaya executed sale deed on 15/11/92.
Said LR under Maraya. Said Marahamaya. Executed.
The said elder of Zeblaya executed sale deed on 15/11/95, conveying the scheduled copy in favor of the petitioner, which conveyance is in question in the proceedings initiated under the provisions of PTCL Act 17/11/2007. Though the proceedings under the provisions of PTCL Act initiated by one Elagaya, fourth respondent, claiming to be grandson of original grantee, despite the sale deed 1995 on the premise of the same, it was contrary to the provisions of PTCL Act. No material has been brought on record to show as to the date on which he learnt about the execution of sale.
No material has been brought on record to show how the said Elegaya is related to the original grantee, and also with regard to the knowledge of his knowledge about the sale deed. Next.
Continue.
Yes. The fact remains that the challenge to the sale deed is made on 17/11/2007 after lapse of 12 years, and we have the law settled down by the apex court in the case referred to above. The petition deserves to be allowed. Consequently, order at annexure G and F passed by the second and third respondent respectively are hereby set quashed. Yes.
Number 30,
Andra, for the petitioner. Or 14% yes, you have to take a permission from the 14% committee. ತಾವಲ್ಲಿ ಕಮಿಟಿ ಇದೆ, ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು. ನಾವು ತಮಗೆ ಅವ್ರು ಗೈಡ್ ಮಾಡ್ತಾರೆ, ಕೇಳಿ ಅವರು. ಡೇಟ್ ಕೊಡ್ತೇವೆ ತಾವು. ತಮ್ಮ ಹೆಸರು? ಶ್ರೀಮತಿ ವೆಂಕಟಮ್ಮ. Respondent number 5 is present before this court. She submit that she would approach the 14% committee and obtain the necessary certificate therefrom. Full stop. List this matter on
28th November.
28th November. ಅದರ ಒಳಗಡೆ ತಾವು ಅಲ್ಲಿ ಹೋಗಬೇಕು. Yes.
Final hearing matters. Number 58.
Oh, yeah, 55, yeah. 55 ಅಲ್ಲ? ಹೇಳಿ. ಏನಾಗಿದೆ 55? ಏನಾಗಿದೆ?
ಅಷ್ಟೇ demolition.
No, we have not declared directly to demolish. They undertook to demolish. We have not passed order to demolish. They said they will demolish 30 days. We said do it in 15 days. That's all.
To that extent, if I can salvage the portion to the extent of the legal permissible.
List this matter on Saturday.
Yes, I can use something.
Later, Shivir Reddy Senior Counsel made representation submitting that the respondent number 1 and 2 have obtained the sanction plan in the year 2022, and it would make necessary submission in this regard. List this matter on that. Yes. Yes.
Serial number 58 is concerned, my lord.
58.
My lord, one of the direction has been questioned in the writ petition, my lord. The deputy commissioner directed the parties to execute in favor of so and so person only. Though the government has permitted to sell the property, but the deputy commissioner directed this land shall be sold in favor of so and so person, my lord, which is irregular under the provision of PTCL Act, my lord. So some of the parties received no objection, my lord, and I am representing some of the ladies only. So therefore, Narayan Swami is also better person to address argument.
Narayan Swami ilvalla. All right.
ಅದು ಒಂದೇ ಪಾಯಿಂಟ್ ಇರೋದು ಸ್ವಾಮಿ.
ಏನು ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆಯಾ?
ಹೌದೌದು, ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ.
Counsel for the parties submit that there is talks of settlement on amongst the parties. What settlement in a government land? Correct. Who are you to settle the government land? If it is allotted in accordance with law, you will get. Otherwise, you can't enter in settlement. All right. Is this matter at the request of the counsel for the parties? 14th November. Yes, 14th November.
Please, man.
Number 59, Ram Mohan.
Yes, ಅದೇ grow more. ಅದ್ ನೋಡಿದ್ರ?
So the terms of the grant, but directed the government education with the original grant.
No, you are supposed to make submission. The judgment which they have produced. Section 43J and G.
In fact, all the decisions on the Bromor scheme. Starting from the Utaya to later.
Yes, ತಾವು ಹೋಗ್ತಾ ಕಂಪಲ್ಸನ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? All right. ಯಾವಾಗ ತಗೊಳ್ತೀರಾ? You receive the copy. Totally. And senior counsel appearing for the respondent number 1. ಯಾವಾಗ ಮಾಡ್ತೀರಾ ಆರ್ಗ್ಯುಮೆಂಟ್? Date. Monday. The request. ಅದಿದೆಯಾ? Monday. Monday.
Two of the direct images not considering the Utaya PTCL Act applies for even in respect of the grant made. But earlier throughout the Mundraju case, the honorable division bench, so they said that without referring to the Mundraju case, that the grantees and the government of PTCL Act is not apply. The subsequent decisions are not based on that Mundraju case.
But the Supreme Court judgment prevails.
And that's what.
Let's see that. Yes. ಕೊಡಿ, ಅದು ಕೊಡಿ. ಅಲ್ಲ, ಅವತ್ತು ಕೊಡಿ. ಮಂಡೇ ಕೊಡಿ. ಮಂಡೇನಾ? ಆಯ್ತಾ? 3 ಸಲ ಮ್ಯಾಟರ್ ಕರೆದು ಇಲ್ವಲ್ಲ. Being spoken to ಮಾಡಿ, we can't keep the matter like this. This indulgence is being misused. You should be ready and the being spoken today itself. Positive time. Yes. Date today. Please give the next set of.
No, I'm sorry.
Your lordship permission, one submission, my lord. Serial number 13 nalli, my name is wrongly shown
as AS Mahesh. I am only S Mahesh. I have also filed a wakalat in it. That may be rectified. Office 13.
Registry is
AS
directed to reflect name of S Mahesh instead
Yes,
of
Mahesh.
AS.
AS Mahesh. Much obliged, sir. Court officer. Court officer.